Honor has directed the collector for taking decision for the thank petitioners has rejected and marked the trees without giving them compensation. NHRC and NCST has already recommended for compensation before 13 years.
We give it memo.
Tomorrow, sir.
Jail criminal appeal of year 2021 में till it not admitted.
I want to make a mention, Your Lordship. The present writ petition memo is for withdrawing the writ petition, Your Lordship. The urgency is that the petitioner has been selected for OJS. For police verification, the urgency is that she needs to show that the matter has been withdrawn.
More than 13 years in custody. Well,
Supplemental list, item number 1.
Wait, results. The last order, if you also looks at, there was a directed me to file an affidavit so that the appeal has been filed against the judgment of the civil justice in the division. Yeah. I filed that affidavit. Flag Flag 8 is there.
That on 12/3/2025, this Honorable Court directed to file an affidavit as to whether the swearing in the judgment can.
That is mistakenly typed out.
Can you sign the petition without reading?
You have signed it. You have signed.
I have signed it.
So why you are second line there?
Say that please. White number. Say to
खाली से word दिता रहिबनी नहीं केना तळे लिखा है कि challenge. Sorry,
that the only word that has been mistakenly typed out.
the swearing should be deleted.
You're not I beg your sincere apologies.
Eta read the third paragraph.
No, this first paragraph is read it out. You read it out.
That on 12/3/2025,
Yes.
this Honorable Court directed to the petitioner to file
The petitioner to direct to the petitioner.
No, लिखा है जी she is reading.
No, correction. About 2 ta कटियो हाँ directed
to
the
file an affidavit as to whether the swearing that will be
All right.
the
whether challenging the हाँ कौन
Challenging for
judgment dated 30/11/2022 and 12/12/2022, respectively passed in CS number 200 of 2016, has been challenged by the opposite party number 5, namely S.K.Sahoo, in appeal before the appellate court.
Dita challenging है वाला. It is the challenging.
So these swearing ta कटिबो. So read the next paragraph.
That in compliance to the said direction, the petitioner is filing this affidavit stating that none of the opposite parties, and more specifically opposite party number 5, namely S.K.Sahoo, has not preferred
Has
any
not ta said रहिबो. Dita non हेगले it becomes positive.
none, Your Lordship. What I
No, you read it. What you mean we understand, but what have you written? We all understand what you mean, but
challenging the judgment and decree dated 30/11/2022 and 12/12/2022, respectively, passed in CS number 200 of 2006.
that is fine. The Aguru none not.
Your Lordship, what I
None hell no, we understand. None hell has रहिबो.
none of the opposite party माने बाकी जो
नहीं कौन ओडिया रे कौन हो कौन तब कहबाऊ चाहउछन ओडिया
none of the opposite
हां
party
ता माने कोनोसी अपोजिट पार्टी
other authorities, they have also not challenged and
कोनोसी अपोजिट पार्टी कोन करनांती
challenge करिनांती
हां ताले सेटा कोन हबो से नोट ता रहिबो कि सेकंड टा ଏଇ ନଅଟା ରହିବନି କାରଣ ଦିଟା ନେଗେଟିଭ ହେଇଯାଉଛି ନା
ଦିଟା ନେଗେଟିଭ ହେଲେ ପଜିଟିଭ ହେଇଯିବ
ଦିଟା ନେଗେଟିଭ
ନନ୍
I'm sorry actually ମୁଁ ତ
And once you made an affidavit, what is the necessity of declaration again?
ଏଇଟା ଫର୍ମାଟ ସାର୍
Format ରେ ଅଛି।
ଫର୍ମାଟ ଅଛି ହାଇକୋର୍ଟ ଫର୍ମାଟ ଅଛି ଆଫିଡେଭିଟ୍
ଆଫିଡେଭିଟ୍ ପରେ ଗୋଟେ ଡିକ୍ଲାରେସନ ଓକେ କିନ୍ତୁ ଆଫିଡେଭିଟ୍ ତ ମିନିଂ ଟା ଓଲଟା ଆସୁଛି
ଗୋଟେ ନୂଆ ଫର୍ମାଟ ଟା ଯୋଉ ହେଇଛି ଆଫିଡେଭିଟ୍ ପରେ ଗୋଟେ ଡିକ୍ଲାରେସନ ତାଙ୍କର ସୁଟ୍ ରେ ଦିଆ ହଉନି କି
Affidavit ତ
ଆଫିଡେଭିଟ୍ ଆଣ୍ଡ
ଭୁଲ ହେଲା।
ଭେରିଫିକେସନ
କଣ କରିବା ସେ ଦିଟା we know what she means but the record ରେ ରହିଲା ଓଲଟା
ଅଲଗା type ର ହେଇଛି।
ଓଲଟା ରହିବି
We take up, Mr. Can we not take up this matter tomorrow
yes ma'am
and just ask him to file another
yes I'll do it
affidavit?
only thing is
and please read it
party has to come he has come to swear the affidavit can I file through my clerk only for correction I'll file it tomorrow
No, if you want, it can come tomorrow.
ଆସ୍ତେ
It's all right. If some mistake has been committed, it is likely to be committed. So there is nothing rectified. We learn by
Yes, correct.
in this process. There is nothing to be. So can we take up tomorrow? Pardon me, Mr. Mr. and senior advocate, put up this matter tomorrow.
Item one.
ଗୋଟେ ଗୋଟେ କିଣି ଦିଅନ୍ତୁ ସେମିତି ଏକାଥରେ ଦେଲେ ଅସୁବିଧା ହବ
ଗୋଟେ ଗୋଟେ
ଫାଷ୍ଟ କଣ୍ଟେମ୍ପ ଟା ଦିଅନ୍ତୁ 4768 ର କଣ ହେଲା
ଦିଅନ୍ତୁ ସେ ଷ୍ଟାମ୍ପ ସେପଟେ ତ ଦରକାର ନାହିଁ 2-1 ଲେଖିବେ 2-1 ଲେଖିଛନ୍ତି ବାସ୍
ଏଇଟା 4768 ର
ହେଇଯାଇଛି କେବେ
ଲାଙ୍ଗୁଏଜ ଲେଖିଦେବେ ଏଇଟା as per
କାଲି ଗୋଟେ କରିଥିଲେ ଆପଣ ନେଇଥିଲେ ନା କାର ସାଂକ୍ସନ କଥା ହଉ
sanction ହେଇ କାଲି ଗୋଟେ ଅର୍ଡର ହେଇଛି item 15 item 15 ଲେଖି ଦିଅନ୍ତୁ ଏଇ ଟାଇପ ର କରିଦେବେ ଡିସ୍ପୋଜ ଅଫ କରିଦେବା ଆପଣ ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ
ଫର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ଟା କୋଟ କରିଦେବେ ନାଇଁ
ଏଇ ଯୋଉ ଲାଙ୍ଗୁଏଜ ଟା ଅଛି ନା ସେ କାଲିର ସେମିତି ଥିଲା ତାକୁ ଆମେ ଟିକେ ମଡିଫାଏ କରିଦେଇଥିଲୁ ବଟ୍ ପ୍ରାକ୍ଟିକାଲି ଏହା ହିଁ ରହିବ ଆଉ ଏଇଟା ଟେକେନ୍ ଅନ୍ ରେକର୍ଡ କରି ଡିସ୍ପୋଜ ଅଫ କରିଦେବ ତାପରେ ନେକ୍ସଟ also complaint ଦିଅନ୍ତୁ remember that direction both side that 5661 next ଟା ବାହାର କର
ସେଟା କଣ ହେଇଛି ନା ହେଇନି ରିଜେକ୍ଟେଡ
ଆଚ୍ଛା ରିଜେକ୍ଟ ଠିକ ଅଛି ଡିସ୍ପୋଜ ଅଫ ହଁ
ଏଟା ଲିବର୍ଟି ଟୁ ଚ୍ୟାଲେଞ୍ଜ
ଏଟା ରିଜେକ୍ଟ ହେଇଛି ପିଟିସନ ରିଜେକ୍ଟ ଲିବର୍ଟି ଟୁ ଚ୍ୟାଲେଞ୍ଜ ଡିସ୍ପୋଜ ଅଫ next 6294 এইটা ଆପଣ ଦେଲେ ସେକେଣ୍ଡ ଟା ଦେଲେ ତ ଠିକ ଅଛି ଯୋଉଟା ରିଜେକ୍ଟ ହେଇଛି we are giving you liberty to challenge
ଡାକିଦେବେ ଯେ ରିଜେକ୍ଟ ହେଇଛି
ଅଛି ତାର ଫର୍ମାଟ ତମେ ଆଗରୁ
ସେଟାର ଅଛି ରିଜେକ୍ଟେଡ
ଯୋଉଟା ରିଜେକ୍ଟ ହେଇଛି ଆଗରୁ ବି ସେମିତି ଡାକିଥିବେ ଟିକେ ସେଇ ଟାଇପ ପୁରା ଲାଙ୍ଗୁଏଜ ସେଇଆ ଏଟାର ସାଂକ୍ସନ ହେଇଛି ହେଲା
ଦେଖିଦବା ଏଇଟା ଯୋଉ କହିଲା ରିଜେକ୍ଟେଡ ହଁ ସିଏ ବି ଠିକ କଥା ଟିକେ ଚେକ୍ କରିଦେଲେ ମିଷ୍ଟର ନାଇଁ ଆପଣ ଯୋଉ ଡବ୍ଲ୍ୟୁପି କଣ୍ଟେମ୍ପ ତା ନମ୍ବର ଟା ଭୁଲ ପଡିଛି ସେ ଚେକ୍ କରିଦେଲେ ଡବ୍ଲ୍ୟୁପିସି ଟା ଠିକ ଅଛି କି ନାଇଁ ଏଇ ଯୋଉ 5661 ଟା what is the read petition number Mr. Behra मधुबन तो हाँ एटा तो मधुबन फिर भी चेक कर दियन
मधुबन से केरल
7906 तो repeat
yes,
the
yes.
number.
श्योर ठीक है साल टिके हम गोटे लाइन लिखिया पड़िबो
Garage out 7906.
हाँ ठीक है सर खाली लिखी दे रहे
नहीं कंटेम्प्ट अरेंज करती कि नहीं नॉट द लेटर
And the content.
repeat ठीक है
ठीक ठीक
सेटा
हम
लिखी
निजे
दे
चेक कर दांगे
arise out of Swansea 7906 hello next এটা হচ্ছে থার্ডটা 6294 6294 এর স্যাংশন হয়ে যাইছে এটা সেই লাইটে রইছে this project copy of the
Yes, sir. This matter also liberty to challenge your
court
6294.
amount challenge
Yes, sir. Lowest amount
আচ্ছা
has been.
it is open to the লিখি দাও
Yes, sir.
ସବୁଥିରେ লিখି দাও at least
তাহলে ফার্স্টটা কিছু চ্যালেঞ্জ করিয়ার নাই থার্ডটা ইউ ওয়ান্ট টু চ্যালেঞ্জ
First also, your lowest amount has been our as per the calendar, not as per the.
ହଉ ହଉ
just you write one line that the land council for the petitioner submitted that the amount which has been sanctioned is at a lower side. Stop. The petitioner is just liberty to challenge it. Appropriate forum. Yes. তো তিনটা গলা তারপরে নেক্সটটা হচ্ছে 632024 320 WPC number 12447 account. It is sanction আছে
This is also same, your lordship.
ସବୁ ତ ସେ ଆଉ
you want to challenge it
Yes, your lordship.
କୋଉଟା
Calculate the compensation, not as per
ঠিক
the
আছে
LRK.
all right we are just putting one line more it is okay next Mr. Nayak 6361
66.
Dion WPC number 30 is back 1 2 321 ঠিক আছে এটা sanction হয়েছে same language লিখে দেবেন disposal next আসলাম 7013 of 2022 1 2 3 1 1 of 24 79 ঠিক আছে next 7033
More time to comply.
আচ্ছা ঠিক আছে এটা লিখে দিন this is 7033 the land council for the state seeks some more time to obtain instruction regarding the compliance of the order dated so and so fasting WPC number so and so है ना because this matter के लिए
କେତେ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ନା କେତେ
first time ଯାଇଛୁ
ସେକେଣ୍ଡ ଟାଇମ୍
November ରେ ଥିଲା first date
Which time?
2 weeks time
ତିନି
same time part of
3 weeks
April 20.
आज है 19
हाँ।
19 ହେଲେ 9 तारिख ରେ
Okay.
हाँ।
9th of April 2025. Next. कौन ହେଇଛି 7382 of 24. Seven 383 of 20. Application number 7621. 7385 of 24. Seven 386. Seven 86 WPC number 1149 of 24. Amount mentioned.
Item 3.
The contempt petition arises from the order dated 24/4/2024, passed in WPC number 9704 of 2024.
Representation disposal.
Representation disposal
First time.
first time.
Quick instruction. First time was. So there will be order each first time say type order for. On date to the queue.
କେବେ ଅର୍ଡର ହେଲା 58
Order was passed on 24 April 2024.
16 तारिख
16. 16/4/2020. Yes.
Item 4.
But in the last passage, that is in the order dated 5 February 2025, the observations of the Honorable Court were uh, the review petition has been filed by the petitioner Sunnalata Panda with a prayer to modify the order dated 29/10/2024 in WA number 1348 of 2000.
No, you can't come to that. Just Asiles 5 to 25 order পড়ে আছেন। Please place that. সেটু ওয়াকামরু পড়ুন।
Actually taken up through hybrid.
সেটা the review petition.
The review petition has been filed by the petitioner Sunnalata Panda with a prayer to modify the order dated 29/10/2024 in WA number 1348 of 2024, and also to set aside the order dated 22/12/2023 passed by the Lord Single Judge of this court in WBC number 8756 of 2019. Inter alia, with a prayer to direct the respondents to give reappointments to the petitioner as a regular teacher and give all subsequent benefits to the petitioner from 2007, which she would have got if she would not have been disengaged illegally. During course of argument, the Lord Counsel of petitioner drew the attention of this court to the order dated 8/1/2018 passed by the Lord Single Judge of this court in WBC number 15386 of 2015, which was filed by the petitioner, wherein the improvement order under Annex 7, that is the rejection order dated 7/8/2015, passed by the collector cum chief executive officer, Jilla Parishad Noyagad, was set aside and the matter was remitted back to the competent authority, that is the collector cum chief executive officer, Jilla Parishad Sarvashiksha Officer Noyagad. That is the opposite party number 3, to give a fresh look to the defense of the petitioner and pass appropriate order taking into account the circulars and resolutions in operation at the time of advertisement release. Lord Counsel of Petitioner placed the order of the Collector District Magistrate Noyagad dated 23/2/2019, which was passed in terms of the order passed by the Lord Single Judge in the aforesaid WBC number 15386 of 2015, and it was observed that the petitioner was appointed as S.K.Sahoo in Doctoral Block in the year 2006 in response of the advertisement of the government. However, when some complaints were made regarding illegality and irregularities committed in the selection process, directions were issued by the collector cum chief executive officer Jilla Parishad Noyagad for recasting of the merit list after due scrutiny of the application forms, and it was detected that the petitioner has filed non-formal instructor in short NFI certificate issued by the DIF of School Bhubaneswar, which should not have been taken into account as per the proceedings dated 30/4/2007 of the District Selection Committee, wherein it has been clearly mentioned that NFA certificate from other educational districts will not be entertained for the time being. It is the contentions of the Lord Counsel for the petitioner that when the advertisement was issued in the year 2006, there was no such stipulations that the NFI certificate from other educational districts shall not be entertained. Therefore, the subsequent decision which has been taken in the proceedings of the District Selection Committee on 13/2007 cannot be a basis to recast the merit list of the petitioner.
Yes, so that is the reason why I will ask you to obtain instruction in the matter. The order is very elaborate. What is your instruction, Mr. Is it correct that in 2006, when the advertisement was issued, there was no such stipulation that this non-formal instructor from the other educational districts shall not be entertained, and only of that particular district is to be entertained. If that is not there, then the selection process has started. Then you took another decision on 34/2007, and there you stated that the NFI certificate from other educational districts should not be entertained. So how this, even if you have taken the decision in 2007 April, so that would have the prospective effect. How can it be retrospective effect for the appointment which was made in 2006?
The instruction. I play with the
We can take off next week. There is. Have you filed that advertisement which was made in 2006? That is a part of the that must be a part of the writ petition also. The running single judge has passed the order against you. So what the division bench said?
division bench not this they ordered that irritable page 24.
You must have raised this point or not? এই ଯୋଉଟା ଆଜି ଉଠଉଛନ୍ତି ରିଭ୍ୟୁ ପିଟିସନ ରେ ଏ ଗ୍ରାଉଣ୍ଡ ନେଇଥିଲେ ଆପଣ?
They have at that time and currently there is no such post of Shiksha Sahayaka. The writ appeal in order the honorable courts observed that as there is no such post of Shiksha Sahayaka, so there cannot be any solution for this matter.
The paragraph 5 and 6. One, that the learned single judge has discussed everything meticulously, and this selection took place in the year 2006, and the post no more exists, so we are not inclined for 2 reasons.
What happened to the Shiksha Sahayaka?
Not only the name, the post name Shiksha Sahayaka is renamed to another name. That is the contractual teacher.
Shiksha Sahayaka.
Have you brought that instructions whether post exists or whether post has
renamed ହେଇଗଲା ବୋଲି you ଆପଣ କହୁଛନ୍ତି, on what basis you are telling?
That I have filed a government resolution Annex 3.
କୋଉଥିରେ ଏଇ writ appeal ରେ file କରିଛନ୍ତି ନା review petition ରେ? Review petition. Annex 3.
Annex 3 page
Okay,
39.
let us see that. That is 2019.
but ସେଇଟା ଯଦି writ appeal ରେ ଦେଇ ନଥିବେ, how can we consider it in the review? Because if it's fresh matter, you have to challenge that order, the higher court. Anyway, let us see. Where is it?
Page 39.
39 full line ଟା ଦେଖା ଏଇଟା rename ହେଇଯାଇଛି. In fact, it is abolish ଯୋଉ word use ହେଇଛି ସେମିତି ହେଇନି, ଏଟା ଖାଲି rename ହେଇଛି. କୋଉଠି ଲେଖା ହେଇଛି?
In the paragraph 1, 2, 3, 4, 5 in pursuant of section 23 of the said act.
Could in pursuant of section 23.
In pursuant of section 23 of the said act, the National Council of Teacher Education, being the academic authority, has laid down the minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 by notification published in Gazette 215 dated so and so, keeping in view the provisions of the said act and rules and the guidelines issued by the National Council of Teacher Education. Government had issued the resolution bearing number ethical dated and corrigendum dated 13/11/2017 in suppressions of this department resolution number 587 SMC dated 10/1/2010 and dated so and so number ethical dated and corrigendum number 2000 SME dated 12/10/2006 and resolution number 224/380 SME dated 14/1/2007 and amendment number to 3817 SME dated ethical prescribed the guideline for engagement of Shiksha Sahayaka, now designated as junior teacher contractual.
Had you filed this in the writ petition?
In the writ petition, there is no such observation made by the and no such ground.
Writ petition observation.
At the time writ petition, there is no such ground.
Mathila, on that ground, it has not been
This ground cannot be.
ଦେଖୁଛି
You have received the instruction in the matter. So by way of an affidavit, you file it, right? The Land Council for the state submits that as for the order dated 5/2/2025, he has received the instruction and the matter may be taken up next week so that an affidavit will be filed from the side of the state. Put up this matter for the 26. Put up this matter on 26 March 2025. Copy of the affidavit. We filed in the meantime, serving copy on the Planning Council for the petitioner. Yes.
Item 5.
review petition କୋଉଠି ground ନେଇଛନ୍ତି ଇଏଟା ଅଛି ବୋଲି Mr. Honda, in your review petition, have you taken that ground that which paragraph? Because for that also you have to apply that the redesignate ହେଇଛି post ରେ
Page 4.
Page 4
Page 4.
of the review petition.
Review petition.
Yes.
Here in the paragraph 2, that the writ appeal has been dismissed by taking a ground that the dispute of the writ appeal is regarding the selection of appointment to the post of Shiksha Sahayaka in the year 2006. But now there is no Shiksha Sahayaka post anymore in government of Orissa. For better appreciation of that, the part of the order, that is paragraph 6 and 7 of the order dated 29/10/2024 in the writ of
page
quoted here.
Page 4 of the review petition. Just
what
page 4, paragraph 2. जो सब paragraph का लिखते हैं, but it is submitted.
so instruction ସେଟା ଆଣିଛନ୍ତି ତ
Has not been abolished by the government of Orissa, rather the name of this one has been changed.
ହେଲା ଛେପ ଗୁଡା ଲଗାନ୍ତୁନି ଫାଇଲରେ ଛେପ ଗୁଡା ଲଗାନ୍ତୁନି
I do not keeping that ऐसे जो ଗୋଟେ ତୁଳା जो ନଥାଏ
କୋରୋନା ଯଦି ଆଉ ଥରେ ଆସିବ
sponge type ର ପାଣି ହେଇକିନି ଏପଟ ଗୋଟେ ସେପଟ ଗୋଟେ ରଖିଦବ କହିଦେଲେ
ଏବେ ଏଟା ଦେଇ ଦେଇଥାଉ ଖାଲି ଗୋଟେ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ରିଭ୍ୟୁ ପିଟିସନ ମାନେ ଇନଷ୍ଟ୍ରକ୍ସନ ପୁରା ଆଣିବେ ଦରକାର ହେଲେ ଆଉ ଟାଇମ ଦବୁ ବିକଜ ବେସିସ୍ ଅଫ ଇନଷ୍ଟ୍ରକ୍ସନ
scope of review petition is very limited. ତେଣୁ ସେ ଗୋଟେ କହୁଛନ୍ତି ଯେ ଅବଜରଭେସନ ଟା ଗୋଟେ ଆସିଗଲା but the document which he has filed that is it's not that it is just it is not abolished but it has been renamed ନା ସେଇଟା ହଉଛି ବାକି ଅନ୍ୟ ଗ୍ରାଉଣ୍ଡ ତ ସେ ଅଲଗା କଥା ଏଇ ଯୋଉଟା ଦେଖୁଛନ୍ତି
it appears to be a valid ground so ଆପଣ ତା ଦେହରେ instruction you should get specific instruction
ଆଉ ବାକି ଯୋଉ ମାର୍କିଂ ଟା ଆପଣ ଯଦି 2006 ରେ ଯଦି ସେମିତି କିଛି ରେଷ୍ଟ୍ରିକ୍ସନ ନଥିଲା ତାହେଲେ ଆପଣ ସେଇ ପର୍ଟିକୁଲାର ଇଏ ପାଇଁ ଆପଣ ସେ 20 ମାର୍କ ପାଇବ
retrospective ହେଇପାରିବନି ଆପଣଙ୍କର
retrospective ହେଇପାରିବନି
ଯାହା ବି ହଉ whatever
yes
ତ ଦିଟା ଜିନିଷ ଏଇଟାର ଇନଷ୍ଟ୍ରକ୍ସନ ଆଉ ଆରଟା ବି ବୁଝିବେ ସେଇ ମାର୍କସ ଟା ମିଳିଲେ whether ସେ ଆସିବ ମେରିଟ ଲିଷ୍ଟ
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ରେ ଏ ସବୁ ଡିଲ୍ ହେଇଛି ନା we want more time
ସେ ଗୋଟେ ଖାଲି ଅଳ୍ପ କଣ ଗୋଟେ
ନାଇଁ ନାଇଁ ସେମିତି ପିସ୍ ମିଲ୍ ଆଣନ୍ତୁନି ତାଙ୍କୁ କହିଦିଅନ୍ତୁ ଅର୍ଡର ଟା ଯୋଉଟା ଇଲାବୋରେଟ ଅର୍ଡର ଟା ପାସ୍ ହେଇଛି କଣ୍ଟେନସନ ବି ଶୁଣିଲେ ଗ୍ରାଉଣ୍ଡ ଦେଖିଲେ ପାରାଗ୍ରାଫ 2 ରେ କଣ ଗ୍ରାଉଣ୍ଡ ନିଆଯାଇଛି ହେଲା ତେଣୁ ଡିଟେଲ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ କିଛି ହରିଟ୍ କିଛି ନାହିଁ ଦେଖନ୍ତୁ କଣ ଲେଖିଲେ ନାଇଁ receive the instruction but on some but the instruction is not elaborate and he may be given some more time to obtain a detailed instruction and to file an affidavit in that respect. So we are adjourning it. We are giving you more time, but obtain a detailed instruction. Now, talking is going to we are
କେବେ ଦରକାର
April
9th April
9/4/2020.
Item 5.
Sorry, I failed to bring the file.
ଏ ତ ବିଦ୍ରୋହ ବୋଧେ ସେଇ
ସେଇ ଗୋଟେ ରହିଯାଇଥିଲା ଏଇଟା ସେ ପ୍ରେୟାର ଟା ରହିକି ଲିବର୍ଟି
ଗୋଟେ ପୁରୁଣା ନମ୍ବରଟେ ଦିଅନ୍ତୁ ଯୋଉଟାରେ ହେଇଥିଲା ମନେ ପଡୁନି ପରେ ବୁଝିକି ଦେଇଦେବେ ଠିକ ଅଛି ସେମାନେ ବି ଖୋଜିଦେବେ ବଟ ଆପଣ ଦେଇଦେଲେ ଭଲ ହବ ସେ ମ୍ୟୁଟେସନ କେସ ର ଅର୍ଡର ଟା ଡାଇରେକ୍ଟଲି ଚ୍ୟାଲେଞ୍ଜ କରିଦେଇଛନ୍ତି ଆପଣ ଡେଟ୍ ଚାର୍ଟ ଟା କଣ ଏମିତି ଦଉଛନ୍ତି ଏତେ ସିନିୟର କାଉନସିଲ ହେଲାଣି ଡେଟ୍ ଚାର୍ଟ ଟା ଖାଲି ଇଣ୍ଡେକ୍ସ ଟା କାଢିକି ଦେଇଦେଇଛନ୍ତି ଡେଟ୍ ଚାର୍ଟ ଆଣ୍ଡ synopsis supposed to help us understand your case ଏଟା କିଛି ବୁଝି ହଉନି
This writ petition has been filed challenging the land council for the petitioner since permission to withdraw this writ petition to approve the appropriate order against the imposed order. According to the writ petition is disposed of again.
କଣ କହିଲେ
ପ୍ରେୟାର ଟା କୋର୍ଟ
ହବ
ସୁବିଧା ହଉଛି
ଥିଲା ସେଇଆ ତ ହେଇଥିଲା
ପ୍ରେୟାର ହିଁ କୋର୍ଟ ପୁରା
ମାନେ
ଠିକ ଅଛି
ଯୋଉଟା ଟିକେ ଦେଖିଦେବେ ଏଇଆ କାହିଁକି ଜାଣିବା yes
Item 6.
My lord, my OGLS application by the annexure 1 is pending before appeal batch number 3.
Yes.
What is the Daringmadi?
yes
That may be disposed for direction.
why should we dispose of which is lying before the Tahsildar Daringbadi
Because my OGLS application is pending before him.
so he will decide
He is not deciding, my lord.
when did you file
My lord, initially I filed in person, then in file.
No.
when did you file
This application which question has been put to you that when you have filed this application
5/3.
in form 1
5/3.
तो 5 तारीख एई मास 5
I've been
तारीख
in person, my lord, file करଥିଲି
5 तारीख एई मास रे आपण फाइल कले आपण गवर्नमेंट लैंड सेटलमेंट एप्लीकेशन देले ए रिट पिटिशन टा केबे फाइल कले
ସେବେ
आउ से ताकू आउ समय फम देबेनी साडे फाइल कर देले
से पहुंच फाइल ହେଇଛି
हां
से एप्लिकेशन ता पाखर पहुंची नथिबे
हाँ।
फाइल ହେଇଛି 5 तारिख रे एप्लिकेशन 6 तारिख रे पोस्टल रे पठेले 7 ତାରିଖରେ ହାଇକୋର୍ଟରେ ଫାଇଲ
ନା ନା ତାପରେ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ନା ନେକ୍ସଟ ଡେ
ଯୋଉ ପେଜ 9 ଆନେକ୍ସର 1
ହଁ
ସେଟା ଫର୍ମ ରେ ଆପ୍ଲାଏ କଲେ
ଗୋଟେ ସେଟଲମେଣ୍ଟ ଲ୍ୟାଣ୍ଡ କରିବାକୁ ହେଲେ
Page
କେତେ
10
ଜିନିଷ ଦରକାର
ପେଜ 10 ନା ପୋଷ୍ଟାଲ ରିସିପ୍ଟ
ତାକୁ କନସିଡର କରିବେ ବିଭିନ୍ନ ଆଙ୍ଗେଲ ରୁ ସେମାନେ ଇଏ କରିବେ 5 ତାରିଖ ସେଠି ଫାଇଲ କରୁଛି ମାନେ ଆପଣଙ୍କ ଡେଟ୍ ଅଫ ଆପ୍ଲିକେସନ ଇଜ 5 6 ତାରିଖରେ ପଠେଇଦେଲେ 7 ତାରିଖ ପଳେଇ ଆସିଲେ ହାଇକୋର୍ଟ ଆସି ବର୍ତ୍ତମାନ କଣ କରିବେ ନା ୟାକୁ ଡିସ୍ପୋଜ ଅଫ କରିବେ
କୋର ଆପ୍ଲିକେସନ ଆର ଦେୟାର ମାଇ ଲର୍ଡ ସବୁଥିରେ ପ୍ଲଟ ନମ୍ବର ଖାତା ନମ୍ବର ସେମ୍
Same all खाते number plot number same man.
dismiss our first
ଦେଖନ୍ତୁ the writ petition has been filed by the petitioner Samson Digol for a direction to the opposite party number भी नहीं को opposite party अपन
Opposite but number 3 man.
opposite party number 3 तहसीलदार दारिंगबाड़ी to consider the grievance of the petitioner on the representation dated 5/3/2025 as per the provision of the OGLS Act 1962.
grievance भी नहीं this is application form
On perusal of Annexure 1, it appears that the petitioner applied for settlement of government land in Form 1 as provided in Rule 5.2 of the OGLS rules on 5/8/2025.
application dated 5/8 কিন্তু sent by
5/3
dated 5/8/2025.
5/3
8 হয়ে দসুচি
5/3/2025, which was sent to the concerned authority
6
on
ତାରିଖରେ
6 ଟା good file ଅଛି ତ
ହଁ
date
ଅଛି ମୁଁ ଦେଖିଛି
ଦୁସୁ নে ডেটটা দুসু
নাই করেছে 6/3/2025 use করেছে
সেটি হ্যাঁ ঠিক আছে
କାଉଣ୍ଟର ନମ୍ବର 2 ତାପରେ 6/3 2000
6/3/2025. So therefore in the prayer portion the mention of the word representation dated 5/3/2025 is not correct since it is an application dated 5/3/2025. Be that as it may, since the application dated 5/3/2025 is sent to the authority concerned on 6/3/2025 and the writ petition has been filed on 7/3/2025, we are not inclined to pass any order in this writ petition. It is up to the authority to consider the application under Annexure 1 in accordance with law. Disposal.
up to 9
Date would have ସବୁ ସମାନ
ସମାନ ଡେଟ୍ ସବୁ ସମାନ only petitioner name
ପିଟିସନ ନାଁ ଗୁଡା ଚେଞ୍ଜ ହବ
my lord
5 to 9 disposal.
Item 10.
But yesterday, Lordship has directed me to look for any recent order. I have obtained one order. In this case also, both departmental proceeding and criminal case initiated on the same charge. And para 3 of the order related to the lodging of FIR and para 4 relating to departmental proceeding.
Yes, which paragraph?
Para 3 may be permitted to reply.
Paragraph 3.
Yes, ma'am. Nevertheless, FIR was lodged in connection with the said irregularities and misdeeds committed by the respondents bearing FIR number so and so for offence punishable under section 409(34) of the IPC by the appellant bank Lakshman Prasad Rattre has also been named as an accused in the FIR. It is alleged in the FIR that Lakshman Prasad Rattre, who had account in the State Bank of India, issued 2 checks in favor of Tanishq Securities, both valued rupees 6,50,000.
No, leave that. It is ultimately what has happened.
Yes, my lord. Ultimately, it's para 21, my lord. Last page.
नहीं FIR ପରେ କଣ ହେଲା?
After FIR, my lord, charge sheet is submitted, and at the stage of prosecution witness, and in departmental proceeding was also initiated against him.
Yes, then what is the observation?
Observation, my lord, para 21, last page.
Para 21.
Yes, my lord.
Yes.
Accordingly, we exercise discretion in favor of the respondent of staying the ongoing disciplinary proceeding until the closure of recording of evidence of prosecution witness cited in the criminal trial as directed by the division bench of the High Court, and do not consider it fit to vacate the arrangement straight away. Instead, in our opinion, interest of justice would be sufficiently served by directing the criminal case pending against the respondent to be decided expeditiously, but not later than 1 year from the date of this order. The trial court shall take effective steps to ensure that the witnesses are served, appear, and are examined on the day-to-day basis. In case any adjournment becomes inevitable, it should not be more than a fortnight when necessary.
You see, several decisions have been taken into consideration.
Yes, ma'am.
In that Captain M. Paul Antony case versus Bharat God Mines.
Yes, ma'am.
And they have summarized it like this, that departmental proceeding and proceedings in a criminal case
Yes, ma'am.
can proceed simultaneously,
Yes.
as there is no bar
Yes, ma'am.
in their being conducted simultaneously, though separately.
Yes, ma'am.
Next, they have decided conclusions.
Yes, ma'am.
If the departmental proceeding and criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is of grave nature, which involved complicated questions of law and fact,
Yes,
it would be desirable to stay the departmental proceedings till the conclusion of the trial.
Yes,
criminal case.
Yes.
Till the conclusion of the criminal. Whether the nature of a charge in criminal case is grave and whether the complicated questions of fact and law are involved in that case will depend on the nature of offense, the nature of case launched against the employee on the basis of evidence, and material collected against him during investigation or as reflected in the charge sheet. Next, the factors mentioned in Roman 2 and Roman 3 above cannot be considered in isolation to stay the departmental proceeding, but due regard has to be given to the fact that departmental proceedings cannot be unduly delayed. 5. If the criminal case does not proceed or its disposal is being unduly delayed, the departmental proceeding, even if that was stayed on account of pendency of the criminal case, can be resumed and proceeded with so as to conclude them at the early date, so that if the employee is found not guilty, his honor may be vindicated, and in case he is found guilty, the administration may get rid of him at the earliest. So this decision is followed thereafter in number of decisions, and so admittedly the consistent view is that both can proceed simultaneously. There is no bar.
Yes.
Number two, they have stated that if the criminal case against the delinquent employee is of grave nature,
Yes.
which involved complicated question of law and fact,
Yes.
then only the departmental proceeding can be stayed till the conclusion of the criminal case.
Yes.
But if after staying the departmental proceeding,
Yes.
it appears that it would take for a longer time to dispose of that criminal trial,
Yes.
then even if it has been stayed, that departmental proceeding has been stayed,
Yes.
that can be allowed to continue.
Yes, sir.
So this is the principle.
Yes, sir.
Now, the observation that has been made by the London Central Administrative Tribunal, which you are placing yesterday,
Yes, sir.
apart from stating in paragraph 7 that how the extent of proof in criminal charge and the departmental proceeding is different.
Yes.
In paragraph number uh, in that paragraph number 6, it is stated that 7.
Yes, not six.
The extent of proof of criminal charge would be beyond any reasonable doubt, while in the departmental proceeding, a person can be found guilty even on reasonable probability.
Yes, sir.
It will be travesty of justice if the respondents are not permitted to complete the departmental inquiry and await the final decision of the criminal trial.
Yes.
If the petitioner is not guilty of the article of charges, the departmental inquiry will be dropped. In view of the above enunciated principle, the dictum that emerges is that there is no uniform principle that whenever a departmental inquiry and a criminal trial is based on somewhat similar fact, the departmental inquiry should essentially be stayed till the conclusion of the trial. Mere similarities of fact per se is not a ground for staying any of the two proceedings. Their scope, ambit, and consequences in fact and law are distinct and different in the instant case. So, you are right that one line in paragraph 5, it has been mentioned that the charge sheet in TR case is yet to be filed.
Yes.
But charge sheet has in fact has already been filed.
Yes.
But in that very paragraph number 5, it is stated that in the criminal case, the question is as to whether you have demanded and accepted the bribe,
Yes.
which is in violation of section 7 of the PC Act or not.
Yes.
That is to be adjudicated. So witnesses will be examined, and in that respect, and if you are found guilty, then you will be sentenced and you have an appeal forum that you will have.
Yes.
It will be tried before the special court.
Yes,
special judge. Now, whereas in the departmental proceeding, the allegation is for violation of departmental rules for withholding the RA bills of the contractor to get the undue advantage.
Yes.
So the scope of these two proceedings appears to be different. So, and the charge sheet has been filed in the year, as you pointed out the other day, yesterday, that the charge sheet is dated. What is the date of charge sheet?
28 October 2024.
28
October 2024.
24.
Yes, sir.
So that means the charge has not yet been framed.
So in the departmental proceeding.
No, I'm asking you about the
criminal
case.
It is the date is just a minute, 30th September 2023. Annexure A by 3, page 48. My lord.
Annexure
A by 3, page 48.
Page 48.
Yes, my lord. In the criminal case.
Just a minute. 15/3/2024 এটা অর্ডার ଆପଣ ଦେଇଛନ୍ତି 15/3/2024 ଆମେ ବର୍ତ୍ତମାନ
15/3/2024 ସେଟା ବେଲ୍ ଆଉଟ୍ ହେଲେ
ଆମେ ପଚାରୁଛୁ ଯେ ବର୍ତ୍ତମାନ ସେ କେସ ର status କଣ ଯୋଉ criminal case ର
it is posted for submission of police paper to 29th April. My lord.
Who filed it? Where is the order sheet?
That the conducting counsel had asked him. It was last listed on 7th March, and on that day police paper could not be submitted, and now it has been posted to 29th April.
How many witnesses are there in the charge?
In the charge, my lord.
In the charge sheet, how many witnesses?
One, my lord.
Just let us see.
The
charge sheet is dated TDC 9/2023, and total number of witnesses to be examined by the prosecution as per charge sheet is 30 ଜଣଙ୍କର ନାଁ ଦେଇଛନ୍ତି. That would be relevant in page number 68 ଅଛି.
Yes.
So 30 ଟା witness examine ହେବେ apart from proving the documents. The total number of documents have been given as 36 documents. So এই case ଟା ଯୋଉଟା ବର୍ତ୍ତମାନ ଏପର୍ଯ୍ୟନ୍ତ police paper ଆପଣ କହୁଛନ୍ତି ଦିଆ ହେଇନି, এই case police paper ଦିଆ ହବ. There may be that thereafter also you may file a discharge petition that is to be considered. तापरे यदि आपनकर reject हला, you may also approach this court challenging that. तापरे ultimately यदि charge frame हला, witnesses summon हो. So in this process, it may take years together to complete the criminal trial. You know, if that would be the state of affair, why the departmental proceeding would be stalled, which has already started, and it cannot be said that it involves a complicated question of law and fact. जोटा कि से a decision रे कहउछन आपण ट्रैप केस रे डिकॉय साक्षी दबो, ओवर हियरिंग विटनेस साक्षी देबे, आ बाकी जो माने पुलिस ऑफिसर्स जाइछंती ट्रैप पार्टी मेंबर्स तांको भितरु किछि देबे एवं ये जदि ए टाइप रो ये रे तादर कॉम्प्लिकेटेड क्वेश्चन ऑफ लॉ एंड फैक्ट कोन रहिला जोटी पाई जे कहउछंती जदि हां सिमिलर थिले मध्य जदि कॉम्प्लिकेटेड क्वेश्चन ऑफ थिबो ताहाले मध्य डिपार्टमेंटल प्रोसीडिंग टाकू स्टे करिवो, वेट करिवो क्रिमिनल केस टा सरीवा पाई. किंतु सेटा मध्य जदि बहुत दिन चलिला क्रिमिनल केस ताहाले मध्य you are to proceed with the departmental proceeding which has been stalled or which has been stayed. एया जदि हला ताहाले ई केस जो क्रिमिनल केस आपनको नारे चार्ज शीट हेची 2023 रे एपर्यंत पुलिस पेपर सप्लाय हेनी बोली आपण कहउचंती जदि सेटा हला जो प्रोसीड्यूर गुडाक ये कि अल्टीमेटली कंक्लूजन हबो it may take years together, so why we will stay the departmental proceeding?
My humble submission is that I have cited on a decision of this honorable court, single bench order, where
we are giving you the decision of the Supreme Court,
yes, ma'am.
and you have also cited one decision, but the principle has been laid down in the Supreme Court elaborately in that case, that captain case,
Yes, madam.
which we pointed out to you. So,
So in the recent the judgment just I handed over my in that para 21, they have taken all these factors into consideration, and they have stated that if there is a delay in
because the charge against you is that it's under Prevention of Corruption Act.
yes, ma'am.
So a corrupted public servant against whom the allegation is that at his instance the bribe has been taken by Y.
Yes.
He would be allowed to continue in that post and to commit all sorts of things because till the criminal trial would be completed will never be found guilty and the departmental proceeding would be stalled what you are submitting. So in this process you will enjoy uh, working in that post for years together even if you are a public servant and the allegation against you that you have committed the uh, um, this act uh, by accepting bribe to discharge your public duty. You have demanded money through Mr. X and he has accepted it. And there is a phone call also. This is the thing, phone call.
But to that, my lord, my humble submission is that in the recent judgment which I gave to the my lord,
Single bench decision of this court.
no, no.
Then?
Just the decision just I handed over to my lord, my lord.
That,
in that State Bank
you
of
see,
India.
the factual scenario of that particular case is completely different from this case.
My lord, in that case, the government official has admitted his guilty. He has committed misdeeds and he has admitted his guilty. In spite of that, learned honorable division bench as well as honorable apex court.
That case was not under the PC Act.
No, that was under 409 of IPC.
PC Act ର case ର ଇଏଟାକୁ ମଧ୍ୟ ଅଲଗା ଇଏରେ ଦେଖାଯିବ ଏ decisions ମଧ୍ୟ ଅଛି.
So it's my
If the charge sheet is filed against a public servant under PC Act,
yes, ma'am.
then the proceeding should not be stalled. Right? PC Act ରେ ଗୋଟେ provision ମଧ୍ୟ ଅଛି trial କୁ stay କରିବନି. The purpose is that it should reach its conclusion at an earliest. Similarly, departmental proceeding can be initiated and can continue, and there is no bar for simultaneous running of these two proceedings. And the stage at which the criminal proceeding is now can be said that it would be concluded within a particular time limit.
But since that is why honorable apex court has stated that if there is a delay in conclude of criminal case, the departmental proceeding can be revived and concluded. Only this much protection I need.
Yes, we have asked also you to find out the decisions. What decisions you have? Respond on the matter. डिपार्टमेंटल प्रोसीडिंग रे आपण केवल एतिकी देखा जीवो जे आपण डिपार्टमेंटल रूल भायोलेट करिकिनी आपण केमती से जो बिल गुडा को से कॉन्ट्रैक्टर रो ताकू केमती विथहोल्ड करिकि रखतो दिस मच is to be adjudicated.
No, my lord. Another fact is that I have, by doing that, I have tarnished the image of the department.
Obviously, that is linked.
And they have.
एथिरे कोन criminal case रे कोन होची जे X has accepted bribe, okay,
Yes, my lord.
from that contractor to clear the bill.
Yes, my lord.
So it is completely different.
My lord, here they are saying that by your instigation, someone else has accepted the money.
ଆପଣଙ୍କର instance ରହିଛି, but the allegation in the departmental proceeding ତାର scope ଟା ହଉଛି different.
No, my humble submission that if that part goes, that it has the money has been bill has been withheld not with some oblique motive, then I will be exonerated from the departmental proceeding, departmental charges.
Yeah.
So here, my lord, they have specific their allegation is that at your instance somebody else has accepted money, and for that the amount has been withheld.
Okay.
So contractor.
That is in the criminal case.
In the debate, Lordship, I am permitted to read the page number 44, my lord, of my read petition.
No.
Page number 44.
What is the papers of departmental proceeding?
Departmental proceeding starts from page 38, my lord. Memorandum of charges starts from page 38. And page 44, my lord, they have stated the region of allegations has been mentioned there. One of the allegations that I have held up the money with some oblique motive.
No, kind memorandum of charges kind.
Memorandum charges, page number 38, Annexure A by 2. President of India proposes to hold an inquiry against Sri Deepak Kumar, staff so and so, the then executive engineer, civil, postal civil division partner holding additional charge of postal civil division Bhubaneswar, presently posted at executive engineer, civil office of superintending engineer, Yoga Bhavan, Kolkata, under Rule 14 of the Central Civil Service Classification, Control and Appeal Rules 1965. The substance of the imputations of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charges. Annexure
Article 1.
Yes, my lord. Annexure 1. Yeah. Article Sri Deepak Kumar, the then executive engineer, civil postal civil division.
Page number कितने?
Page 41, my lord. Page 41. I'm sorry, page 41. Additional charge of executive engineer, civil postal civil division Bhubaneswar during 2/6/22 to 14/4/2023 issued a work order number so and so to Sri Prasanna Manika for the work of repair and maintenance of postal staff quarters, block PTN 134-145 at new P&T colony, sector 6, Raurkela. Sri Deepak Kumar and executive engineer, civil postal civil division Bhubaneswar entered into conspiracy with Sri Subhasis Pal, assistant engineer, civil postal civil division Sambalpur, and withheld an amount of Sri Prasanna Manika contractor from first and second RA bill to obtain undue advantage from the contractor for releasing the withheld amount. Thus, by the aforesaid act, Sri Deepak Kumar has tarnished the image of the department, committed gross misconduct, and failed to maintain devotion to duty, and thus acted in a manner unbecoming of a government servant, and misused his official position, thereby violating Rule 3(1) I and XB of Central Civil Service Conduct Rule 19.
So, what is the article of charges that that Subhasis Pal has accepted the bribe, and at your instance the bribe has been accepted? Where is those?
Page 44.
Huh?
Page 44.
Page 44. Article of charges se season sochi.
Statement of imputation.
Statement chhadandu mo. ଆପଣଙ୍କ ନାଁରେ ଯୋଉ ଚାର୍ଜ ହେଇଛି ଚାର୍ଜ ହଉଛି ଏତିକି ତାରି ଉପରେ ଫାଇଣ୍ଡିଂ ଆସିବ.
Yes, my lord. But in the imputation they are saying
ଏଇ ଯୋଉ ଏଇ ଚାର୍ଜ ଯଦି ଆପଣଙ୍କ ନାଁରେ ଆସିଲା, can a finding be given that you have accepted that Subhasis Pal has accepted the bribe, and at your instance, he has accepted the bribe.
with
And ସେ ସବୁ ଜିନିଷ ନାହିଁ।
conspiracy ବୋଲି ସେ କହୁଛନ୍ତି ତ।
Conspiracy କଣ ପାଇଁ? Conspiracy ଯେ you have withheld that bill amount.
Yes, madam. And
That is all.
It has been elaborated.
Criminal case ରେ total different. ଯେ ଆପଣ withheld କଲା ପରେ ଆପଣ ତାକୁ ଟଙ୍କା ମାଗିଲେ, ଏତିକି ଟଙ୍କା ଦେଲେ ବିଲ୍ କ୍ଲିୟର ହବ ନହେଲେ ନାହିଁ, ସେଥିପାଇଁ ସେ ଯାଇକିନି ଅଥରିଟିଙ୍କୁ କମ୍ପ୍ଲେନ କଲା, ଡ୍ରାଫ୍ଟ ଲେଟ୍ ଡାଉନ୍ ହେଲା, ଡ୍ରାଫ୍ଟ ଲେଟ୍ ଡାଉନ୍ ପରେ ଆପଣଙ୍କୁ ତାଙ୍କୁ ଯେମିତି ହବା କଥା that you were caught red-handed. You means that Subhasis Pal was caught red-handed, and that money was recovered from him,
Yes,
and he submitted that at your instance. Then a phone call was, so that is a totally different thing. That criminal case.
But that portion has been reflected in the imputation in the departmental
No,
proceeding.
that is exactly why the learned tribunal has said that this is totally different. That departmental proceeding is for allegation for violation of the departmental rules and for withholding the RA bills.
Yes, madam. And so far as that
Withhold କଲା ପରେ ତାପରେ ଯୋଉ consequence ହେଇଛି, ଟଙ୍କା ଡିମାଣ୍ଡ କରିବା, ତାଠୁ accept କରିବା, ଏଇ ସବୁ ଜିନିଷ ସେଟା ପାଇଁ criminal case ଟା ହେଇଛି।
ସେ କହିଲେ sir ଯୋଉ conspiracy part ଟା କହିଲେ, and I entered into conspiracy with Subhasis Pal, and that conspiracy has been
What is the decision se cite କରୁଛନ୍ତି? Which paragraph, madam?
7 and 8.
7 and 8. Please place it. Please place it. Please.
My lord, in para 7, it has been submitted here. It is fairly well settled position on law that on basic principles, proceeding in criminal case and department proceeding can go on simultaneously, except where department proceeding and criminal proceeding are based on same set of facts and evidence in both the proceedings common. Now here it is totally different manner, because they have demanded a bribe and a CBI inquiry has been made, and my lord, in para 8, the purpose of the departmental inquiry.
And in the departmental proceeding, you see those witnesses, ए जो trap एमती हल्ला, FIR एमती हल्ला, तापर एमती trap टा successful हल्ला, ये जिनसो departmental proceeding रे तांकर प्रमाण करिवा किछि दरकार नाही।
Witnesses are same in both the cases.
आपण बुझुचन ना सेथरे से जिनसोटा होची totally different. आपण आधीरे से माने खाली डिपार्टमेंटल प्रोसीडिंग रे एती पर्यंत जिवे जे सी कंसिस्टेंटली तार काम करि देछि, बिल टा देछि एवं बिल आपण डिलेट करूछंती, which is was not proper and justified. That is how you have not acted in terms of the, so that is only the scope of departmental proceeding. Criminal case आसी जानतु से withheld कला परे टंका मागिले बिल क्लियर करिया पई, तापर से जाई कंप्लेन देला परे ड्राफ्ट पार्टी आसिले, प्री डिटेक्शन प्रोसीड्यूर हला, तापरे डिकॉय आसिला, ओवर हियरिंग विटनेस ता संगे गला, केमती गला से केमती ड्राफ्ट हला, केमती रिकवरी हला. So obviously those demand, acceptance and recovery, those three essential ingredients to prove that charge under section 7 of the PCI is required to be proved by the prosecution. So for that the witnesses will be examined. Those witnesses they are not required to be examined in this case because the scope is different. The article of charge is different. Deliberately delay korauthile.
But my lord, they have the same persons, those who are witnesses before the criminal case are also witnesses before in the departmental.
Please, paragraph 8.
My lord, para 8, my lord. The purpose of the departmental inquiry and of prosecution are two different and distinct aspects. Criminal prosecution is launched for an offense for violation of a duty the offender owes to the society, or for breach of which law has provided that the offender shall make satisfaction to the public. So crime is an act of commission in violation of law or of omission of public duty.
The departmental inquiry is to maintain discipline in the service and efficiency of public service. It would therefore be expedient that the departmental proceedings are conducted and completed as expeditiously as possible. It is not therefore desirable to lay down any guidelines as inflexible rule in which the departmental proceeding may or may not be stayed pending trial in criminal case against the delinquent officer. Each case requires to be considered in a backdrop of its own facts and circumstances. There would be no bar to proceed simultaneously with departmental inquiry and trial of a criminal case unless the charge in the criminal trial is of grave nature involving complicated questions of facts and law. Offense generally implies infringement of public duty as distinguished from mere private right punishable under criminal law. When trial for criminal offence is conducted, it should be in accordance with proof of the offence as per the evidence defined under the provisions of the Indian Evidence Act 1872. Converse is a case of the departmental inquiry. The inquiry in a departmental proceeding relates to conduct or breach of duty of the delinquent officer to punish him for his misconduct defined under the relevant statutory rules of law. That the strict standard of proof or applicability of the Evidence Act stand excluded is a settled legal position. Under these circumstances, what is required to be seen is whether the departmental inquiry would seriously prejudice the delinquent in his defense at the trial in a criminal case. It is always a question of fact to be considered in each case depending on its own facts and circumstances.
Yes. This case is also quoted there also. Captain M. Paul Anthony case.
Now permitted to place only two paragraphs by page 44. Page 44. Second and third paragraph. May I permit it?
What is this for page 44?
Page 44 of the repetition, my lord.
It's a witness of statement of the witness.
No, my lord. Page 44. It starts with hence an amount of. Page 44 of the
ସେଟା start ହେଇଛି page 42 ରୁ
statement of computation. Page 42 it starts from page 42, but the relevant page I want to submit my
yes
page 44.
yeah
Sri Prasanna Manika filed a CBI complaint on the demand of bribe by Sri Subhasis Pal, Assistant Engineer Civil. During trial proceeding by CBI, Sri Subhasis Pal was caught with bribe money and he voluntarily accepted
ଠିକ ଅଛି ତା statement ସେଗୁଡାକ
and
record ହେଇଯାଇଛି.
last my lord,
Yes.
thus Sri Deepak Kumar sought undue advantage. So the departmental proceeding has been initiated against me on the basis of this incident, my lord.
All right. Look, this petition has been filed by the petitioner Deepak Kumar, who was working as executive engineer civil in the office of superintending engineer Yoga Yog Bhavan, Kolkata. He is now working as executive engineer.
No, yes, well, he is now working as
He is now working as one. Has filed this petition. Now, petition has been filed by Swan, so challenging the order dated 26 to 2025, passed by the Plan and Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 59 of 2025. it appears that where is that article of charges or page number?
Page number 41. Page 41.
From the article of charge framed against the petitioner, it appears that while he was working as executive engineer civil, postal civil division Patna, while holding the additional charge of executive engineer civil, postal civil division Bhubaneswar during 2/6/2022 to 14/4/2023, he issued a work order number 1531 dated 23/12/2021 to Prasanna Manika for the work of repair and maintenance of postal staff quarters block PTN 134-145 at New P&T Colony, Sector 6, Rourkela. It further appears from the article of the charge framed that he entered into conspiracy with Sri Subhasis Pal, Assistant Engineer Civil, Postal Civil Subdivision, Sambalpur, and withheld amount of Sri Prasanna Manika, contractor, from first and second RA bill to obtain undue advantage from the contractor for releasing the withheld amount. And thus the petitioner has tarnished the image of the department, committed gross misconduct and failed to maintain devotion to duty, and thus acted in a manner unbecoming of government servant and misused his official position, thereby violating Rule 3(1), 3 bracket ভিতরে 1, তারপরে bracket ভিতরে Roman 1, outer bracket Roman 2, Roman 3, and XB of Central Civil Services Conduct Rules 1964. Stop. The article of charge dated 28/10/2024 was served on the petitioner by way of a memorandum along with a list of documents and a list of witnesses by whom the article of charge is proposed to be sustained. And the petitioner was directed to submit a written statement of his defense and further to state whether he desired to be heard in person within 15 days. And it was informed to the petitioner that an inquiry will be held only in respect of those article of charges which are not admitted, and therefore he should specifically admit or deny the article of charge. On receipt of such memorandum, which consists of article of charge and the statements of witnesses and documents, the petitioner submitted the written statement.
No, ma'am.
You have not submitted.
No, I have submitted a representation.
The petitioner submitted a representation. Can I say representation?
At page 75. And answer A by
Just a minute. Submitted a representation 75.
Yes, ma'am.
Before the Undersecretary to Government of India, Ministry of Communication, Department of Telecommunication. केबे submit कले on 2/12/2024.
Yes.
Wherein he indicated that since on the self-same ground, a criminal case under section 7 and 12 of the Prevention of Corruption Act, read with section 120B of the Indian Penal Code, by CBI case number RC05A of 2023, which corresponds to TR case number 14 of 2023, is subjudiced before the London Special Judge CBI Court number 1, Bhubaneswar, and the charge sheet and public article of charges of the disciplinary proceeding and the criminal case are based on identical and similar set of facts, and the witnesses in both the cases are same, and the documents relying on for the charges in the criminal case are also relied on in the charge sheet of the departmental proceeding, in case he files the written statement of defense, he will be highly prejudiced in the criminal case. And therefore, a prayer was made to keep the departmental proceeding in abeyance till the conclusion of the criminal case stop. On receipt of such representation, what the authority did?
No order has been passed yet.
The authority has not passed any order. However, the petitioner approached the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 59 of 2025. What is the original application?
Annexure A by 2.
Annexure A by 2.
Page starting from page 19.
19
page annexure to 2, page 19.
90 था
19 एक
19 अच्छा. In which the prayer was made to pass the order oblique file number 10 oblique AOL oblique 2025 dated 29/1/2025 of respondent number 3. Who is that respondent number 3?
Subranil Das, the inquiring authority, my lord.
Respondent number 3, that is Subharnil Das, inquiry authority. And an interim prayer was made to stay the departmental proceeding initiated against the petitioner till the conclusion of TR case number 14 of 2023. The London Central Administrative Tribunal had order dated, by an impugned order dated like that, 26 to 2025, has been pleased to hold that the charge sheet in the TR case is yet to be filed. However, the criminal case is for demand and acceptance of the bribe, which is in violation of Section 7 of the PC Act, whereas in the departmental proceeding, the allegation is for violation of departmental rules for withholding the RA bills of the contractor to get undue advantage. The Lund Tribunal relied upon the ratio laid down by the Honorable Supreme Court in the case of State of Rajasthan versus Sri B.K. Meena and others, AR 1997, Supreme Court, page 13. As well as Kendriya Vidyalaya Sangathan and others versus Sri Srinivas, AR 2004, Supreme Court, 4127, and came to hold that the extent of proof of criminal charge would be beyond reasonable doubt, while in the departmental proceeding, a person can be found guilty even on a reasonable probability. And it would be travesty of justice if the respondents are not permitted to complete the departmental proceeding and await the final decision of the criminal trial. The London Tribunal further held that if the petitioner is not guilty of the article of charges, the departmental inquiry will be dropped, and there is no uniform principle that whenever a departmental inquiry and a criminal trial is based on somewhat similar facts, the departmental inquiry should essentially be stayed till the conclusion of the criminal trial. Stop. Mere similarity of facts per se is not a ground for staying any of the two proceedings. Their scope, ambit, and consequences in fact and law are distinct and different, and accordingly, the interim relief which was claimed by the petitioner for staying the inquiry in the disciplinary proceeding was rejected. You are Mr. Parshuram Mahapatra.
Yes, sir.
Mr. Parshuram Mahapatra, Land Counsel, appearing for the petitioner, challenging the impugned order, argued that from the statements of the witnesses which have been supplied to the petitioner with the memorandum and article of charges would indicate that the allegations in both the cases are almost identical, and if at this stage the petitioner would file his written statement in the departmental proceedings, he will be seriously prejudiced, as he is likely to disclose his defense and the we should have adverse effect in the criminal trial. The London Council further urged that the London Central Administrative Tribunal aid in observing that charge sheet in the TR case is yet to be filed. In fact, the charge sheet in the said case has already been filed on 30/9/2023 before the London Special Judge CBI Court number 1, Bhubaneswar, in TR case number टा कहते हैं TR case number
14 of 2023
14/2023, and the case is now posted for supply of police paper to the petitioner. The London Council has placed reliance in the case of ଆପଣ ଏ ଯୋଉ ଏଇଟା ଦେଲେ ତ ଯୋଉଟା
SBI versus
SBI
Nilam Nag.
placed reliance in the case of SBI and others versus Nilam Nag and another reported in এটা দেখিয়ে দেবে কোথায় রিপোর্ট হয়েছে হ্যাঁ
2016-19 SC.
just click
49.
then yes. Wherein the Honorable Supreme Court took into account that the charge in the criminal case is for the offense under section 409/34 of the Indian Penal Code, and further held that the pendency of criminal case against the respondent Neelam Bag cannot be the sole basis to suspend the disciplinary proceeding initiated against the respondent for an indefinite period, and in the larger public interest, the order as passed in Stangen's case, bracket like the reference to the be followed even in the fact situation of the case, to balance the equities. The Honorable Supreme Court considered clause 4 of the Memorandum of Settlement and held that it is to be kept in mind the larger public interest, bracket, at least in case of involvement of the employees of the public sector banks in offense of breach of trust and embezzlement, bracket ends. The arrangement predicated in case of Stangen, bracket case would meet the ends of justice. The disciplinary proceeding instituted against the respondent cannot brook any further delay, which is already pending for more than 10 years. And accordingly, it was held that the ongoing disciplinary proceeding is to be stayed until the closure of recording of the evidence of the prosecution witnesses cited in the criminal trial. With a further direction that the criminal case which is pending against the respondent is to be decided expeditiously, but not later than 1 year from the date of the order. And the trial court shall take effective steps to ensure that the witnesses are served, appear, and are examined on day-to-day basis. Stop. The ଆପଣ କାହା ନାଁ ଲେଖା ହବ? ସୁଲୋଚନା ପାତ୍ର. This is Sulochana Patral and Central Government Council with Mr. C.K. Padi, and Deputy Solicitor General, on the other hand, supported the impugned order and placed reliance in the case of State Bank of India and others versus R.V. Sharma, reported in 2004-7 Supreme Court cases, page 27. Stop. Adverting to the contention raised by the learned counsel for the respective parties, on perusal of the charge sheet, we are of the view that the contention which has been made by the learned counsel for the petitioner, that the Learned Central Administrative Tribunal has erroneously reflected in paragraph 5 of the order that the charge sheet in the TR case is yet to be filed, is correct. Stop. In fact, the charge sheet, कितना number page? The charge sheet was filed on 39/2023 under section 7 and 12 of the PC Act bracketary as amended in 2018 bracket ends, 1988, reduced section 120B of the Indian Penal Code against one Subhasis Pal and the petitioner, Subhasis Pal, Devendra Kumar Kuhan and the petitioner Deepak Kumar. As per the charge sheet, the Subhasis Pal, Assistant Engineer Civil, Postal Civil Division, Sambalpur, demanded bribe of rupees 1.5 lakhs from the complainant Prashanna Manika, contractor Bhubaneswar, on 4/4/2023 to release his withheld bill amount of rupees 3,77,585. Due to compulsion, the complainant gave rupees 25,000 at the first instance, and for the remaining amount of remaining bribe amount of rupees 1.25 lakhs, and further instruction to pay the bribe of rupees 18,500 to the petitioner for releasing withheld bill amount. The complaint was lodged before the CBI authorities. Trap was laid and the trap became successful. And after investigation of the case, the IO came to the conclusion that from the oral evidence, documentary evidence, and material exhibits, it appeared that the accused Subhasis Pal, while functioning as a public servant, demanded and accepted the bribe oblique undue advantage of rupees 1,22,500 for himself and rupees 18,500 for the petitioner, and further he arranged another contractor, Devendra Kumar Puhan, for depositing the bribe amount in the bribe of amount of the petitioner in the bank account of Devendra Kumar Puhan, and the said Subhasis Pal entered into criminal conspiracy with the petitioner and thus it was found out that they have demanded and obtained the bribe amount of rupees 1.41 lakh bracket लिखी दियंतु rupees 1.22,500 for himself and 18,500 for Deepak Kumar from the complainant. Stop. From the article of charges which was placed by the learning counsel for the petitioner, it appears that page number
41.
that the charge was very specific, that the petitioner entered into criminal conspiracy with Sri Subhasis Pal and withheld an amount of withheld the amount of Sri Prasanna Manika, comma contractor, from first and second RA bill to obtain undue advantage from the contractor for releasing the withheld amount. There is obviously nothing in the article of charges that the Subhasis Lal demanded any bribe from the contractor, and he accepted the bribe amount. Which is obviously the subject matter of the criminal case sub judice in the court of so and so. In the case of Captain M. Paul Antony versus Bharat God Mines, reported in 1999, bracket with three Supreme Court cases, 679, the Honorable Supreme Court held as follows for this paragraph. In the case of Secretary, Ministry of Home Affairs and others versus Tahir Ali Khan Tyagi, reported in so and so a reference to name. It is held that the departmental proceeding and criminal proceeding can run simultaneously, and departmental proceeding can also be initiated even after acquittal in a criminal proceeding, particularly when the standard of proof in a criminal proceeding is completely different from the standard of proof that is required to prove the delinquency of a government servant in a departmental proceeding, the former being one of proof beyond reasonable doubt, whereas the latter being one of preponderance of probabilities. So, in the case of R.B. Sharma, bracketary Supra, the Honorable Supreme Court also relied upon the case of Captain M. Paul Antony and held as follows, paragraph number 8 of case further. 8 and also 11 of code further. No. In the case in hand, so far as the institution of the criminal case is concerned, even though the offense was committed, the FIR was lost. The complaint was lost. The complaint was lodged on 10/4/2023, and charge sheet was submitted on 30/9/2023. But the police papers are yet to be supplied to the petitioner. So also the co-accused person, so also the two co-accused persons. The charge sheet indicates that as many as 36 documents are to be proved, so also 30 witnesses are to be examined. Obviously, it would take a longer time for the prosecution to conclude the trial. So far as the departmental proceeding is concerned, the Learning Central Administrative Tribunal is quite justified in holding that the departmental proceeding is for violation, has been initiated for violation of departmental rules for withholding the RA bills of the contractor to get undue advantage. Obviously, in the departmental proceeding, it is not to be inquired into whether the petitioner or anyone at the instance of the petitioner demanded or accepted any bribe amount, which is the subject matter of the trial, criminal trial. In view of the settled position of law, and particularly when the scope of the two proceedings are different in nature, stalling the departmental proceeding till the conclusion of the criminal trial would be not proper and justified, particularly when their scope, ambit, and consequence in the fact and law are distinct and different. In view of the foregoing discussions, we do not find any infirmity in the impugned order passed by the learning tribunal. Accordingly, the writ petition being devoid of merit stands dismissed. Yes.
Item 11.
This is yesterday's matter. No? I'm handing over the copy of the OA.
What is your prayer in this?
The prayer is to pass the order of the tribunal, dismissing my application matter challenging the order of transfer.
Oh, transfer.
Yes.
We wanted to know, you made a submission
Well,
that there is no such vacant post.
yes. So which period I was transferred?
Please come to that order, transfer order.
Well,
That is at page.
that is at page annexure 7, madam.
Annexure
At
7.
page 32.
You are Prashant Kumar
Prashant
Sahu,
Kumar Sahu, assistant.
assistant,
Madam.
and your present place
At Bhubaneswar, madam.
SMU branch,
Madam.
Bhubaneswar,
Madam.
and you are posted or transferred to
Branch of
JK. JK4.
Yes.
So by showing that
Annexure 8,
revised data under annexure 8
page 34.
in serial number 13,
Yes.
you said that there is no such vacant post for you.
Yes.
And we asked
There
you.
is no post, my lord. Mr. S.N. Rao is appearing for the.
My lord, we are appearing for OP2 to OP4, my lord. You are filing the wakalat number, my lord.
Yes.
My lord, the question is with respect to the post, my lord, whether the post is available or not, my lord. But my lord, here, my lord, the designation, the pay scale, and the service condition of the petitioner, my lord, over here is remaining unchanged, and due to administrative.
ଆପଣ ଜଣ ଗୋଟେ ଜାଗାକୁ ପଠେଇବେ,
my lord,
ସେଠି ତା ପାଇଁ ଭ୍ୟାକାନ୍ସି ନଥିବ, ସେ କ'ଣ କରିବ?
My lord, see vacancy only my submission is that ମୁଁ ତାର ଏଇ present designation ସହିତ I am only changing the place of posting, my lord. ସେଠି vacancy, my lord, the only thing is that I have in the counter file, my lord, I have explained why the transfer is being, why the present petition is being transferred.
No. That is your, no doubt, in exceptional cases, when it is a malified one, that is, but he is raising a very vital point. Suppose you are taking one employee from one place to another. So he has to work or sit idle there and get the salary.
No, my lord, he has to perform a.
So which post he will perform? What if there is no vacancy?
Say he present with assistant भाବରେ perform करिवो the duty he will be disbursing his duty as
ଆପଣଙ୍କର पर ସେଠି vacancy ଆପଣଙ୍କର total post ଅଛନ୍ତି ଦେଖଉଛନ୍ତି total ହଉଛି 3ଟା post ସେଠି. Is it not correct? they ଯୋଉ annexure 8 ରେ ଗୋଟେ post ହଉଛି କଣ grade 2 ର
manager grade 2.
ହଁ.
One is my lord UDC, another is my lord MTS. And assistant of the public head clerk my lord 0.
ହଁ ସେଗୁଡାକ ମାନେ vacancy ଅଛି ନା କଣ?
That was only there is no post my lord assistant category ki head clerk category post nahi.
अच्छा.
And if you also kindly turn to annexure 6. Annexure 6 my lord 4 post of assistant is lying vacant at Anugu.
No, we are not there. हमें एटी जोटी ट्रांसफर कले हमें सेठी के आसिया.
Yesterday, your lordship wanted to see whether I have taken that plea before the tribunal. First, my lord, I have taken my representation on the same day, 14/11/2024, indicating the same thing.
Page number?
Page number, representation, my lord, same date, annexure 9, page 36. Apart from my grievance, my lord, in page 37. In the last 2 paragraphs, my lord, it is pertinent to mention here the branch office. JK Pur doesn't have any sanctioned post of assistant.
Yes, so what is your reply? You are appearing for whom?
My lord, I am appearing for OP2 to OP4, my lord. Yes, yes, sir. Yes,
2,
Yes, I got
3, 4 तीन जनों ପାଇଁ.
yes, ma'am.
देखिए कौन फाइल କରିଛନ୍ତି चलो. You are appearing for the Union of India.
Yes, ma'am.
Your OA has been dismissed.
Yes.
So, what was your stand in the before the Central Administrative Tribunal about this particular submission which is making?
Before the Central Administrative Tribunal, my lord, My stand is that, my particular stand is that, my lord, if my lord has the counter in the OA that had filed, my lord.
Yes, this is the counter,
my lord.
which you have handed over to us.
The counter in the OA, my lord.
No, counter
it
matter,
has
your lordship
already-
will get an annexure to have annexed that.
Oh, your
Annexure 10, my lord, page 39.
page 39.
Yes, you start from page 39.
Ah.
And about this particular aspect, my lord, your lordship will get at
Page 7. The internal page 7, my lord.
Internal page number 2.
page 44. I have referred to as per clause 2.2 of the transfer policy. And about this particular post, madam, they have not denied that there is no vacancy. Madam, page 45, para second para.
My lord, there we have stated what was the necessary for that transfer, my lord. My lord, page number, the para 8.3, my lord.
8.3. Yes.
8.3. That on the other hand, internal page 7, on the other hand, owing to the acute shortage of officer in the cadre of Social Security Officer branch manager, the Social Security Officer posted at Berhampur has been given the additional charge of branch manager, branch office Jaipur. Because of his dual responsibility, the branch manager, branch officer Jaipur has to remain at Berhampur for 2 or 3 days in a week. The posting of Sri Prasant Kumar Sahu, the present petitioner, in branch office Jacob was ordered, keeping in view that being an assistant with sufficient experience of working in branch offices, he could take charge of the branch officer during the absence of branch manager, and thereby the service delivered to beneficiary would continue smoothly and uninterruptedly. Thus, the posting of Sri Prasant Kumar Sahu branch officer is the best interest of needy workmen and beneficiary of the area for smooth function of the office. Next stand, my lord, is that, my lord, he's the present service condition, the designation as well as the pay scale, my lord, that is remain unaltered, my lord. My lord, here it's the prerogative of the employer, my lord.
No, that we don't. Nobody dispute about
I'm not disputing that.
Say things, my lord. So here, my lord, the only stand is that ମୁଁ employees ମାନଙ୍କୁ proper place ଯୋଉଠି ମୋର need and requirement ମୁଁ use କରୁଛି, and for that ମୋର କିଛି ତାଙ୍କ ନା service condition change ହଉଛି, usual TADA ଦିଆ ହଉଛି, everything is in place, my lord. On special duty ଯୋଉଟାକୁ କୁହାଯାଏ, my lord.
You join this.
This writ petition has been filed by the petitioner Prashant Kumar Sahu, who is working at present as head clerk public assistant in ESI Corporation, Odisha region, challenging the order dated 4/3/2025, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00678 of 2024. In dismissing the original application, it appears that the original application was filed with a prayer to quash the order dated 14/11/2024 under Annexure 7, wherein the petitioner was transferred and posted to branch office JK Purkama, Rayagada, on administrative exigency, with note that he shall be entitled to TA/TA and joining time as per the rules, and is to relieved from the post with effect from 14/11/2024. The Learning Tribunal has been pleased to hold that when the competent authority transfer him to a place like JK Poor, it is up to the authority concerned to allow him to continue to his transfer post after he reports to the duty. And the contention of the petitioner that there was no such post of head clerk public assistant exists in the branch office of JK Poor, for which the transfer order was illegal, was not accepted, as it was held that the petitioner has failed to produce any document that the transfer is actuated with mala-fide exercise of power. Mr. Tripathi, learned senior advocate, appearing for the petitioner, placed the transfer order and under Annexure 7 and also the revised data of the officers under Annexure 8 and argued that it would be evident from these two documents that there is no such post available at JK Poor for the petitioner, and therefore the order passed by the authority transferring the petitioner is not sustainable in the eye of law. Stop. Mr. Nihal Roth, Land Counsel, has entered appearance for the opposite parties number 224 and by filing Wakalatnama, and Mr. Gopal Krishna Nayak, Land Central Government Council, has filed the memo of appearance, which are taken on record. Peruse the counter affidavit filed by the opposite parties number 3 to 4 before the Central Administrative Tribunal. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Since the parties have already entered appearance, let extra copy of the writ petition be served on the Land Council for the opposite party number 1, also the Land Council for the opposite parties number 2 to 4. Put up this matter in the week commencing from, so when will put this matter, because you have to file the counter affidavit.
The reply to this.
Right.
My lord, I will be not changing my stand because
It's all right.
One
Put up
2 weeks.
7. 7th or 8th, 9th,
Just on 9th.
this matter on 9th of April 2025.
Interim order, my lord, because I am still continuing. And they have been paying, my lord, the salary that has been reflected in the order.
No, they're paying, that is fine. But there they need your work there. So you join. If you find any illegality, we'll set it aside. But you join. In the meanwhile, you join. Because they've expressed why they need your services there.
Lord,
Because you have worked for 3 years here.
Well,
So that way transfer is not malified.
no, but if you also look at the policy, transfer policy.
No, we decide.
Man,
so
No
those things will
violation
be
of transfer
adjudicated.
provision in any provision. That is on.
Man,
That's all. এগুলো সব matter খালি নিয়ে আসবে।
Much good.
Madam, additional custody for more than 9 years.
Madam, more than, but you mention fresh admission. More than 9 years.
More than 9 years fresh admission.
But careful let's see, because आगे जो delay in custody period also admit होगा.
ओहो এইটা হম আরে ফ্রেশ অ্যাডমিশন রে 9 ইয়ার্স করা দরকার কোন
Sure.
Supplemental list, item number 1.
Lord sir, my lord, this is filing before the virtual High Court Barampur. Due to some difficulties, I may permit to move my lord to this Kandati Council. We have power in this.
have power or don't have power?
I have also power.
If what permission is required, you have filed the appeal and you have got the power.
Yes,
So you can trace the matter. What is the problem?
the virtual court judge.
What is your good name?
Ved Prakash Pandit.
Hmm. What is this criminal appeal for?
This is the under against the order of the District and Session Judge Parampe in ST case number 1 of 24. That is against the conviction, madam. Conviction is for life and 10,000 fine. 302 is.
Call for the trial court record, interim application for bail and stay realization of fine be considered after receipt of the trial court report. In the meantime, the learned counsel for the appellant will supply the deposition copies of all the witnesses.
Already filed.
You filed? Have you?
We file along with the appeal.
Police paper, yes. ठीक है
Inter police.
और Mr. B.P. Panda. Yeah.
Item 2.
Wait, please, the surrender period of the appellant is not yet expired. It is supposed to expire on 19th March. Ajit. He has already surrendered. He's
6-3-25 that was correct. The land council for the appellant submits that surrender date is fixed to today, and she has received instruction that the appellant has already surrendered and some time may be granted to produce the surrender certificate. Is this matter? 2nd of April 2025.
Much obliged.
Item 3.
What report from the IIC? Clearing rest of the investigation direction to submit a report regarding breadth of appellant number. I'm submitting. The conductor, the London Council for the State, has produced the written instruction received from Inspector in charge of Southern Police Station. IIC IIC Southern Police Station from regarding the conduct of appellant number.
Conduct nahi, death
report. Oh, dates.
already.
That appellant number 2, Chandri Devuri is dead. The report is
Dead since 10 years.
Since 10 years. No? The report is taken on record. This criminal appeal, so far as appellant number 2 is concerned, awaits. With this matter in usual course. Yes.
Item 4.
I am on behalf of Mr. Dhala. Mr. Dhala is not there for the treatment. He went to Mumbai. So kindly 2 weeks time may be granted.
You have got power in this case. What is your name, Sandhya? So and so. Submits on behalf of Mr. D.P. Frog. For an adjournment for 2 weeks. With this matter.
Is 9th all right? You are getting 2 weeks. 9th all right?
Yes.
9, 2020.
You also read the file in case it is not very difficult. You can also do it.
Okay.
Item 5.
My lord, on behalf of Sunny Mr. My lord, accused of surrender in time, my lord. What a surrender certificate not received.
So you will you produce it or will you take instruction from the trial court?
No, already
ଆପଣ ଆପଣ ମୌଖିକ ଭାବରେ କହୁଛନ୍ତି ଯେ ସେ ଅଲରେଡି ସରେଣ୍ଡର କରିସାରିଲାଣି। ଆମେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦେଇଥିଲୁ, ଅର୍ଡର ଥିଲା ଯେ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ପ୍ରଡ୍ୟୁସ କରିବେ। ଯଦି ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ପ୍ରଡ୍ୟୁସ କରିବା ପାଇଁ ଆଉ ଅଧିକା ସମୟ ମାଗୁଛନ୍ତି ନା ଆମେ ଟ୍ରାଏଲ କୋର୍ଟରୁ ବୁଝିବୁ ଆପଣ ସରେଣ୍ଡର କଲେଣି?
ଟାଇମ୍ ଥିଲା।
ହଁ।
ନା
You are Mr.
Vijay Kumar Parida.
Vijay Kumar Parida. Mr. Vijay Kumar Parida, appearing on behalf of Mr. Satyanaran Mishra, submits that he has received instruction that after availing the interim bail period, within the deadline, 2 सप्ताह, as per order dated 19/2/2025 in IN number 37 of 25, the appellant has already surrendered in the trial court, and some more time may be granted for production of the surrender certificate. Place this matter on place this matter on 2/4/2025.
Item 6.
Item number 6, the Lordship are directed to produce the conduct certificate of the accused.
report regarding non-surrender certificate received. सामान्य कौन? Non-surrender certificate.
21/2020.
मैंने तो देखिए कोई हारे वीडियो वाला मानने वाला वीडियो वाला।
Surrender plan in unavailable warrant of arrest.
अच्छा ट्रायल तो पहला।
देखो, here is the report of the Learning Trial Court dated 21/1/2025, from which it appears that after availing the interim bail period, the appellant has not surrendered, for which an unavailable warrant of arrest was issued against him on 7/1/2025. Stop. As soon as the appellant is taken into judicial custody, the trial court shall intimate this court. Stop. A copy of today's order be communicated to the learning trial court by the learning registered judicial.
So the report on 12/1/25, this may not be.
Surrender colony of the conduct adverse nine would have come.
Report again, 12/1 may not be.
The Land Council for the state has produced a report dated 12/1/2025 of the IAC of Ratho police station regarding the conduct of the appellant, which is taken on record.
Item 7.
Last copy the Lordship directed report from the Ujjain Lordship. So the report from the OSP, whether he is the permanently regarding on the Saikada police station.
Yes.
Whether the accused persons who is residing permanently under the Saikada police station.
You are in judicial custody since 2017.
17, your Lordship.
And
10/7/2000.
you are a man from Madhya Pradesh. So that is why the State Council took time to obtain instruction as to whether the address furnished in the impugned judgment is correct or not. And SP Denkana shall make necessary communication to so and so. What is your instruction?
Can you some more time since they are
No, communication has been made already.
Communication is already.
The IN number 28 of 2025. The Land Council for the State submits that as for order dated 5/2/2025. Instruction has already been sought for by the Superintendent of Police Telangana from Superintendent of Police 5/2 in the state of Madhya Pradesh, that the same is awaited and the matter may be taken up after 2 weeks. No?
After 2 weeks.
After 2 weeks for
you can
them.
put up 3 weeks.
After 2 weeks, 9th of April 2025.
Item 8.
Kindly adjournment of this matter to next week.
Jail criminal appeal.
What is your good name?
Okay, sir. Narendra Kumar.
So why was it listed? It's the 19/2.
Bail or ये point station. Just here.
हाँ. 19/2.
You are mentioning on behalf of Sanjay Narayan Sahu.
On behalf of Akshay Kumar Sahu.
Akshay Kumar Sahu, not Sanjay sir.
Akshay Kumar Sahu did have time needed.
Akshay Kumar Sahu. Council appearing for. Akshay Kumar Sahu, 6 for an adjournment. How many weeks you want?
For
March 2025.
इंस्ट्रक्शन आणले मॅडम इथे जो
Yes, sir.
19 वर्ष जो अच्छी
The proposal was moved since October 2020. It's still
Weekly list. Which number items are
item 2 weekly.
2. এটা কেবে রয়েছে আজি গেছি বড়
इंस्ट्रक्शन कोण आणले
Remember relief I moved it 20th 110 to move it. Still pending.
अच्छा he is still in custody.
Still in custody.
So 1/10/2024 को देंगे. So latest as on today he is in custody.
He is in custody.
কোড বললে কোড ফোন নম্বর ଅଛି ଆପଣ ପାଖରେ বললে কোড Parties man
The meeting was held, he was hiding.
ସେମିତି ନାହିଁ ଖାଲି
When the meeting was held, the accused was hiding.
Hiding. Cross-examination, the first line. And the other day, your lordship was checking whether that can be called as voluntary or not.
That is the. It means a decision.
I'm not the right person to hand over this.
And the language, see you decision to place in classes,
Eta may be
circumstances in which the confession is made. That is also to be looked into. Say circumstances jane voluntary nature confession ହେଇପାରିବ କି ନାହିଁ ତେଣୁ ଜଣେ ଜଣେ ଲୁଚି ଥିବ ତାକୁ ଗାଁ ମିଟିଂ କୁ ଡାକିକିନି ତାକୁ କ୍ୱେଶ୍ଚିନ୍ କରିବ ସେଠି ଯଦି ବି ସେ କହିଲା whether it would be a voluntary nature or not.
I'm submitting in judgment. It just goes against my interest. Still,
what is your interest in that? Nothing against your interest. You can say
that
against the case.
Public prosecutor duty hochi not to see that the case ends in conviction.
Yeah, I've handed over the decision. I'm sure this takes care of the
that is he should be an impartial person.
Yes.
Police janare charge sheet dela she trial face korchi mane the public prosecutor should not presume and act accordingly that this man is somehow or other I should to prove the whatever they are.
When I joined this side, I spoke to someone when I really adore. He said, state never loses. Either it wins or a citizen wins. I go by that.
Yes. So even if there is some material in favor of the appellant, and the appellant's counsel misses it, that also you should point out.
Especially in this decision, what happened? He was called to the village meeting. There were 30 persons were present, where she was asked about the reason of the death and she confessed. The court held that in this episode, when 30 persons were asking the accused, this cannot be, that confession cannot be called as voluntary. That is how she was acquitted.
Meeting really decision
Yes, sir. On the side of the state commission, I would like to present 3 more judgments, which says extrajudicial confession need not need any corroboration. If it is trustworthy, I'll submit to your lordship.
So better to give that in a list that this is against, this is for, so it will be.
Yes. The appellant counsel is on the way. Some mental failure and all is on the way.
Yeah. Because the decision relied on in this court, they are saying the
Yes, sir.
In appropriate cases, extrajudicial can also form the basis of conviction.
So, repose confidence ଯାହା ଉପରେ ହେଲା ମାନେ କ୍ଲୋଜନେସ୍ ଯୋଗୁ ଯଦି ସେଇଟା ବି ବିଲିଭେବୁଲ ହବ ତାହେଲେ କିଛି ଇଏ ନାହିଁ ବଟ୍ ନର୍ମାଲି ଦେଖିବାକୁ ପଡିବ ସେଇଥିପାଇଁ ଯେ କାହା ପାଖରେ କନଫେସନ ଅଛି କ୍ଲୋଜନେସ୍ ରହୁଛି କି ନାହିଁ କଣ ପାଇଁ ତା ପାଖରେ କନଫେସ କରିବ ମାନେ କଣ ତାର ଇଏ ରହିବ ଏଇ ସବୁ ଜିନିଷ ଜଣେ ଆସି ମନେ କରନ୍ତୁ ତାର ଗୋଟେ ବେଷ୍ଟ ଫ୍ରେଣ୍ଡ କି ଫ୍ୟାମିଲି ମେମ୍ବର ଏଇ ଟାଇପ ର ତାଙ୍କୁ କନଫିଡେନ୍ସ ରିପୋଜ କରିକିନି କିଛି କହିଲା so there is can be acted upon so that is why even though it is stated that it is a very easy to create such evidence and it's a weak piece of evidence so the corroboration is necessary but they said that even if there is no corroboration but the extrajudicial confession appears to be voluntary and the witness is also appears to be unbiased and he was no way inimical to the accused and he would gain nothing by falsely implicating the accused. In such a situation, that can be acted upon.
On the other day, I've placed reliance on 2 judgments. That's are not given in repetition. So kindly, may I place the 3rd judgment?
Yes, sir.
Serial number 3rd. Can I please? Paragraph 14 and 15 would be relevant. I'll place that. That is fine. Place at the flag 3, the first flag named as flag number 3. Paragraph 12, 13 number.
Paragraph, no, is a Antony case, no? MK Antony case.
Yes. I'll place from paragraph 14 directly. The next question is whether the evidence as to extrajudicial confession is by itself trustworthy and credible or there are any other circumstances which may tend to devaluate its credibility and hence the need for corroboration to the judicial confession before placing implicit reliance on them. Paragraph 15. There is neither any rule of law nor of prudence that evidence furnished by extrajudicial confession cannot be relied upon unless corroborated by some other credible evidence. The courts have considered the evidence of extrajudicial confession a weak piece of evidence. In Sahoo versus State of UP, it was held that an extrajudicial confession may be an expression of conflict of emotion, a conscious effort to stifle the strict conscience, an argument to find excuse or justification for his act, or a pertinent or remorseful act of exaggeration of his part in the crime. Before evidence in this behalf is accepted, it must be established by the causant evidence that there were exact words used by the accused. The court proceeded to state that even if so much was established, prudence and justice demand that such evidence cannot be made the sole ground of conviction. It may be used as a corroborative piece of evidence. In that case, the evidence was that after the commission of murder, the accused was heard muttering himself that he was finished deceased. The High Court did not interfere with the conviction, observing that evidence of extrajudicial confession is corroborated by circumstantial evidence. However, in Piara Singh versus State of Punjab, this court observed that the law does not require that evidence of an extrajudicial confession should be in all cases be corroborated. It thus appears that extrajudicial confession appears to have been treated as a weak piece of evidence
but there is no rule of law nor rule of prudence that it cannot be acted upon unless corroborated. If the evidence about extrajudicial confession comes from the mouth of the witness or witnesses who appears to be unbiased, not even remotely inimical to the accused, and in respect of whom nothing is brought out which may tend to indicate that he may have a motive for attributing an untruthful statement to the accused, the words spoken to by the witness are clear, unambiguous, or and unmistakably convey that the accused is the perpetrator of the crime, and nothing is omitted by the witness which may militate against it, then after subjecting the evidence of the witness to a rigorous test on the touchstone of the credibility, if it passes the test, the extrajudicial confession can be accepted and can be the basis for a conviction. In such situation, to go in search of corroboration itself tends to cast a shadow of doubt over the evidence. If the evidence of extrajudicial confession is reliable, trustworthy, and beyond reproach, the same can be relied upon, a conviction can be founded there.
In spite of such observation,
Yes, sir.
the Honorable Supreme Court discussed what are the circumstances.
There were
And found
circumstances.
that there are dying declaration,
Yes, sir.
there is leading to discovery.
Yes, sir. In paragraph
all
20,
those
there's
things
some.
are there. That is how the conviction was sustained.
Yes, sir.
Right. So it is not that it is a case where only basing on general principle they have discussed that.
That is regarding the principle.
So what other decision you are relying upon?
Thereafter, the PRSing which is relied upon in MK Anthony, I'll place paragraph number 10, you know. That is a flag 4.
Flag 4.
Flag 4.
Yeah.
I'll only place the paragraph 10.
Paragraph 10.
At the last page, page 459. May I?
It eyewitness कौन अच्छी?
There are other, but this is regarding the whether the extrajudicial confession can only be the basis of the conviction.
No. You are relying on this PR Singh.
PR Singh.
PR Singh paragraph 10 re.
Yes.
Thus taking.
Yes. That was leading to discovery also.
Eyewitnesses achanti, recovery achi,
but
evidence of ballistic expert achi, esu jinso pore.
The empty
extrajudicial confession.
Yes. In that case, if his lordship was held, it may place it. Thus, taking an overall view of the picture presented by the prosecution case, we find that there is sufficient evidence against the accused to prove the charge of murder against them. The evidence of eyewitness is fully corroborated by the medical evidence, the evidence of recoveries, the evidence of ballistic experts, and the evidence of P.W. Balbir Singh, who deposed regarding the extrajudicial confession made by the accused P.R. Singh. The learned session judge regarded the extrajudicial confession to be very weak type of evidence and therefore refused to rely on the same. Here, the learned session judge committed a clear error of law. Law does not require that the evidence of an extrajudicial confession should in all cases be corroborated. In the instant case, the extrajudicial confession was proved by an independent witness who was an irresponsible officer and who bore no animus against the appellants. There was hardly any justification for the session judge to disbelieve the evidence of Balbir Singh, particularly when the extrajudicial confession was corroborated by the recovery of an empty cattle solution from the place of occurrence. I was just placing that if there is any other corroboration, if it is trustworthy, the extrajudicial confession can form the basis of the confession. And thereafter, the last judgment is of Sahadev. Your Lordship, the Apex Court has laid down the principles regarding the admissibility of the extrajudicial. May I read the only?
No. You are relying on the evidence of 4 witnesses.
4 witnesses.
We are putting a question to you.
Yes, sir.
That whether any of these 4 witnesses have stated that I was present in that meeting and in my presence, the accused confessed.
Yes, sir. I'll just replace the evidence of 267 years.
You come to one by one.
One.
You say PW1. Has he stated that I was present in the meeting?
The PW1 is also the irreducible. I'll just place it.
No. He कौची ना extrajudicial confession विषय अपन कौचने तो सी तो पुनी meeting रे निजे present रही था Please come to that portion where he has stated that he was present in.
The PW1 is the informant in this case, Your Worship.
हाँ नहीं नहीं
Yes.
से
May I
କହିଛି କି ମାନେ ମୁଁ meeting ରେ present ଥିଲି.
I'll just reread the
ଆରେ
entire.
ପଢୁନାହାନ୍ତି.
I know that this is Radhika. Accused is her husband. They were my co-villagers. The deceased died about 2 years back. About 2 years back, just before the Dashera, during evening hours, Moti Naik and Bhagirathi Naik of our village came and told me that accused Bhagwan Naik has killed his wife by means of a tangia. Hearing the news, we rushed to the house of the accused and found the deceased were lying dead on the front veranda and found the bleeding injuries on her neck, backside of the neck, waist. The panchayat meeting was held in the village. The same day, the accused was called to the meeting. On being asked, he confessed before everybody that he suspected his wife of infidelity, and hence he has killed her.
Generally, he has not stated I was present in the meeting. And in my presence, this thing was asked.
Yes.
That's a very vital part. Otherwise,
Yes.
he has to say that I have. You see, otherwise it would be a hearsay evidence from
Yes,
which source he got it.
Yes.
ଆପଣ କହିବାକୁ ପଡିବ ନା ଯେ ମୁଁ ମିଟିଂ ରେ ଉପସ୍ଥିତ
ଥିଲି
ଥିଲି ଏଗୁଡାକ କୁହାହେଲା ଆଉ ଗୋଟେ ମିଟିଂ ହେଲା ସେଠି ମିଟିଂ ରେ ମଧ୍ୟ ସେ ମାନିଲା ଦୋଷ ମାନିଥିଲା ତ ଏ ଟାଇପ ର come to PW2 has he stated that he was present?
I'll just read it. I know the accused person, accused and the deceased. They were my co-villagers. The deceased, who is the wife of the accused, died 2 years back. On the date of occurrence, which was immediately before Dashera, during the evening hours, one Bhagirathi Naik came and reported that the accused has killed the wife by a tangia. On hearing the news, we rushed to the house of the accused and found the deceased lying dead on the veranda of the house with bleeding injuries. Thereafter, a meeting was held in the village pertinent to the incident, and accused was called to the meeting. On being questioned, the accused admitted his guilt by stating that he has killed his wife by a tangia because she was a bad character female. Thereafter, FIR was lost. Police came to the village, effected seizure of bloodstained tangia. Thereafter, Your Worship, he has not particularly stated that he was present.
Nobody has
Yes, sir.
stated. You see what section 60 of the Evidence Act says. Section 60 says that the oral evidence must be direct. Oral evidence must in all cases whatever be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it.
Yes, sir.
If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it.
Yes, sir.
That means ଯଦି ତମେ କହୁଛ ଯେ meeting ରେ ଏମିତି ହେଲା ତାହେଲେ you must be the person who should be present
in that meeting first.
and heard it from the accused saying so. Otherwise, your evidence would not be acceptable. It would be hid by section 60. It would be hearsay evidence.
Yes, sir.
Right?
Yes.
So, कौनसी witness आपनकर जो 4 जन witness कहउचंती has none of them has stated that they were present in the meeting, and in that meeting, in their presence, this accused has made the statement.
Yes. They only said that he confessed before everybody. There is no specific.
Generally,
Yes.
generally.
So, weapon of evidence doesn't carry the bloodstains. That also.
କଣ ହେଲା?
Even the weapon of offense doesn't.
ଆଉ କିଛି evidence ନାହିଁ, only ହଉଛି extrajudicial confession. ଆପଣଙ୍କର ଟାଙ୍ଗିଆଟା ଯୋଉ ମିଳିଲା ତା ଦେହରେ blood ହିଁ ନାହିଁ, ଆପଣଙ୍କର C report on the exhibit 70.
ଏଇ କେସରେ ଅଛି. That is the other case.
ନା ଗୋଟେ ଥିଲା ଲୁଙ୍ଗିରେ ବ୍ଲଡ ଥିଲା ଟାଙ୍ଗିଆରେ ନଥିଲା ଏଇଟା
ସେଟା ଖାଲି ଯୋଉଟା ଥିଲା ବେଲ୍ ପାଇଁ ସେଟା ଥିଲା ଏଇଥିରେ ବ୍ଲଡ ଷ୍ଟେନ୍ସ ଅଛି ପେଜ 46
page
46 ରେ the forwarding report ସେଟା କହୁଛି ଯେ
no 47 ଟା ହଉଛି C report.
ରିପୋର୍ଟ ଟା
47 is the report. Tangia mark as A, no blood.
no blood.
Sari
My
B,
apologies.
no blood. Check lungi C, blood, and nail clippings accused no blood. Sample earth no blood, so and so.
So this is the case. ଲୁଙ୍ଗିରେ blood ମିଳିଛି human blood but grouping
I was
କେମିତି ହେଲେ କେମିତି ହବ
law ବି ସେଟା କହୁଛି ଖାଲି weapon of offense ଟାକୁ connect କଲେ ବି ହବନି. That should be the chain should be complete.
because ଗୋଟେ weapon ଯଦି ବି ତା instance ରେ ଜବତ ହେଇଛି, unless you link it to the crime, that offense, it cannot be.
Cannot.
But where is that madam? What police? ଆଶ୍ଚର୍ଯ୍ୟ।
फोन धरलेନି तुमको गाड़ी खराब ହେଇଯାଇଥିଲା ଓହୋ ଦେଲା ନା
Appeal number 86 of 2009. The appellant, Bhagwan Naik, faced trial in the court of ad hoc additional session judge, FTC, Malkangiri, in criminal trial number 28 of 2008 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 10/9/2006 at about 7 p.m. in his house situated in village Kedaguda, he committed the murder of his wife Radhika Naik, bracketry, hereafter the deceased, bracket ends. The London trial court had judgment and order dated 9/12/2008 found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000, in default to undergo RI for a further period of 6 months. Stop. Part. The prosecution case, as per the first information report lodged by PW1 Bhaktaram Pujari before the officer in charge of Mudulipada police station on 11/9/2006, in short, is that on 10/9/2006, in the evening hours at about 7 p.m., the appellant dealt 5 to 6 Tangia blows to the deceased on her head, ear, and back, suspecting her character, as a result of which the deceased sustained bleeding injuries and died, and her dead body, along with the dead body of a male child, of their baby, was 20 days, were lying in the courtyard of the house. The informant got the news from the co-villager Bhagirathi Naik and rushed to the spot. And he found the dead bodies and further found that the appellant was standing there, being armed with a tangia, and was shouting. It is further stated in the FIR that the village meeting was convened over this issue, and the appellant was asked about the occurrence, and he confessed his guilt and stated to have killed the deceased by dealing blows with tangia, suspecting her character. It is further stated in the first information report that on account of rain in the night on 10/9/2006, early report could not be submitted in the police station. Stop. On the basis of such written report presented by PW1, Mudulipada PS case number 20 dated 11/9/2006 was registered under section 302 of Indian Penal Code against the appellant, and Sub-Inspector of Police R. Sabbar took up investigation of the case. On his transfer, the investigation was charge of investigation was taken over by PW8 Niranjan Behera, who re-examined some witnesses, sent the exhibits to RFSL Barampur through SDGM Malkangiri for chemical examination, and on conclusion of investigation, he submitted charge sheet against the appellant under section 302 of the Indian Penal Code. Since the SI R. Savar, who investigated the case from 11/9/2006 till the charge was handed over to PW8 on 28/12/2007, the documents prepared by the said SI R. Savar were proved by PW8. in order to, no, after submission of the charge sheet, the case was committed to the Court of Session, where the Learning Trial Court framed charge as aforesaid, and since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resetted to establish his guilt. In order to prove its case, the prosecution examined 8 witnesses. Prosecution also exhibited 17 documents. The defense plea of the appellant is one of denial. The Learning Trial Court, next para, after assessing the oral as well as documentary evidence on record, came to hold that the death of the deceased has been proved to be homicidal in nature. The Learning Trial Court relied upon the evidence of the witnesses relating to extrajudicial confession made by the appellant before in the village panchayat, and came to hold that such confession coupled with leading to discovery of the weapon of offense under section 27 of the Evidence Act, chemical examination report and medical report establishes the charge under section 302 of the Indian Penal Code against the appellant. Ms. Mandakini Panda, Land Counsel, appearing for the appellant, argued that there are no eyewitnesses to the occurrence and the case is based on circumstantial evidence. And the evidence adduced by the witnesses like PW 1, 2, 6, and 7 relating to the confession in the village panchayat is not trustworthy. And PW3, who has also stated that the meeting was held in the village after the dead bodies were found, the accused did not come to that meeting. And only after the lodging of the FIR, when the police came, the accused was brought. The Land Council further argued that evidence on record indicates that the appellant and the deceased were living peacefully, and for 8 to 9 years, and no motive has been proved on the part of the appellant to commit the crime. And so far as the evidence of leading to discovery of Tangia is concerned, the concerned investigating officer R. Savar, the SI of police, has not been examined in the trial court, and only the disclosure statement of the appellant recorded under section 27 of the Evidence Act by Exhibit 6 has been proved by the prosecution, but there is no evidence on record that on the basis of such disclosure statement, the appellant led the police party and the witnesses to the place of concealment of the weapon and produced the weapon which was seized. And therefore, the recovery cannot be accepted in law. Moreover, the seized Tangia was sent for chemical examination, and the chemical examination report by Exhibit 17 indicates that no blood was found on Tangia. It is argued that even if the Tangia in question was seized at the instance of the appellant, which was having no blood in it, and which was also not produced during trial to be marked as a material object, the same cannot be utilized as a circumstance against the appellant, since it has not proved to be the weapon of offense. It is argued that the circumstances available on record do not form a chain so complete to come to irresistible conclusion that it is the appellant alone who has committed the crime, and therefore the impugned judgment is liable to be set aside. The Land Council for the state Ms. Shubhalakshmi Devi, on the other hand, supported the impugned judgment and cited decision of the Honorable Supreme Court in the case of State of UP versus M.K. Antony, reported in 1985, 1 Supreme Court cases 505, Tiara Singh and others versus State of Punjab, reported in 1977, bracket ভিতরে রইব 4 Supreme Court cases 452 and Shahadevan and another versus State of Tamil Nadu reported in 2012 bracket ভিতরে রইব bracket bar 6 Supreme Court cases 403 and submits that if the extrajudicial confession is trustworthy and reliable, the same can itself be the ground to convict the appellant, and the witnesses who have deposed about the extrajudicial confession has got no animosity with the appellant to depose falsehood, and therefore the London Trial Court is quite justified in accepting the evidence of these witnesses and convicting the appellant under section 302 of the Indian Penal Code. Adverting to the contention raised by the London Council for the respective parties, there is no dispute that in the case in hand, there are no eyewitnesses to the occurrence, and the case is based on circumstantial evidence. It is the settled principle of law that in order to base conviction of an accused under basing on circumstantial evidence, the prosecution is required to prove that each of these circumstances to be firmly established, and the circumstance cannot be explained under any other hypothesis. The circumstances taken together must form a complete chain, and there is no escape from the conclusion that it is the accused and accused alone who is the author of the crime. The off-quoted decision on this principle is there in the case of Sharad Gritchand Sarda versus Swansea, 84 Supreme Court Swansea. The main circumstance which is appearing in this case is the extrajudicial confession of the appellant in the village meeting, which is stated to have been held after the occurrence, and the relevant witnesses are PWs 1, 2, 3, 6, and 7. Though PWs 1, 2, 6, and 7 have stated about the confession being made by the appellant in the village meetings, but we find that none of them have stated that they were present in the meeting and they have heard the appellant making confession in their presence. PW1 has stated that the appellant was called to the meeting and on being asked, he confessed before everybody that he suspected the deceased of infidelity and hence he killed by a tangia. In the cross-examination, he has stated that when the meeting was held, the accused was hiding and the meeting was held on the southern danda of the village. He further stated that the appellant and the deceased were living together peacefully. PW2 has also stated that the appellant was called to the meeting and on being questioned, he admitted his guilt and stated that since the deceased was of bad character, he killed her by a tangia. So far as PW3 is concerned, he stated that pertaining to the incident, one meeting was held in the village, but the accused did not come. And after the lodging of the first information report, when the police came, the accused was brought. He further stated in the cross-examination that the appellant and the deceased were staying peacefully as husband and wife for about 8 to 9 years. The evidence of PW3 that he did not come to the meeting place and he was brought only after the police came to the village creates doubt in the evidence of the witnesses like PWs 1 to 6 and 7 who have stated that the appellant came and made extrajudicial confession in the village meeting. PW6 has stated that after the occurrence, there was a panchayat in the village which was attended by all the villagers. And on being asked, the appellant admitted his guilt and stated that he had killed the deceased by means of a tangia. In the cross-examination, he has stated that the appellant and the deceased were staying as husband and wife and having children, and they had no history of quarreling with each other. So far as PW7 is concerned, he has stated that after the occurrence, there was a meeting, there was panchayat in the village, which was attended by all the villagers, and the appellant, on being asked, admitted his guilt, saying that he had killed the deceased by means of a tangia before everybody. The though in the evidence of PW1 and PW2, it appears that in the meeting, the appellant stated the reason for killing his wife, bracket the deceased, but the evidence of PW6 and PW7 is silent in that regard. Law is well settled that extrajudicial confession is a weak piece of evidence and requires appreciation with a great deal of care and caution. Stop. It is to be proved just like any other fact, and the value thereof depends upon the veracity of the witnesses to whom it is made. The words of the witnesses must be clear, unambiguous, and should clearly convey that the accused is the perpetrator of the crime. The court has to satisfy itself in regard to the voluntariness of the confession, truthfulness of the confession, and independent, reliable corroboration. Whenever the court, upon due appreciation of the entire prosecution evidence, intends to base conviction on an extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by other prosecution evidence. If, however, the extrajudicial confession is surrounded by suspicious circumstances and suffers from material discrepancies or inherent improbabilities and does not appear to be cogent as per the prosecution version, its credibility becomes doubtful and it loses its importance, and it may be difficult for the court to base a conviction on such a confession. In such circumstances, the court would be fully justified in ruling such evidence out of consideration. However, an extrajudicial confession, if voluntary and true and made in a fit state of mind, can be relied upon by the court, and conviction can be founded thereon if the evidence about the confession comes from the mouth of the witnesses who appear to be unbiased, not even remotely inimical to the accused, and in respect of whom nothing is brought out which may tend to indicate that he may have a motive attributing an untruthful statement to the accused. It is but a natural curiosity to ask as to why a person of sane mind should at all confess and what benefit he would get by making such confession. Extrajudicial confession, in order to afford a piece of reliable evidence, must pass the test of reproduction of exact words, the reason or motive for the confession, and the person selected in whom confidence is reposed. In the case of uh, M.K. Antony, bracket supra, the Honorable Supreme Court has held as follows. Quote from paragraph number 15. However, we find that even the Honorable Supreme Court, after holding that if the evidence of extrajudicial confession is reliable, trustworthy, and beyond reproach, the same can be relied upon and a conviction can be founded thereon, discussed the other evidence on record, like time declaration, the leading to discovery of the weapon of offense, etc., and on that basis found that the prosecution case to be proved. In the case of Tiara Singh, bracket supra, the Honorable Supreme Court, though held that the Lennon session judge aid in law in refusing to rely on the extrajudicial confession, holding that it is a very weak type of evidence. And that law does not require the evidence of an extrajudicial confession should in all cases be corroborated. Base the conviction relying on the evidence of the eyewitnesses to the occurrence and other materials on record. In the case of Sahadevan, bracket supra, the Honorable Supreme Court has relied upon the decisions, number of decision of the Honorable Supreme Court, and came to hold that the extrajudicial confession is a weak evidence by itself, and it has to be examined by the court with greater care and caution, and that it should be made voluntarily and should be truthful, and it should inspire confidence. Stop. It is further held that the extrajudicial confession attains greater credibility and evidentiary value if it is supported by a chain of cogent circumstances and is further corroborated by other prosecution evidence. Stop. For an extrajudicial confession to be the basis of conviction, it should not suffer from any material discrepancies and inherent improbabilities. Stop. Such statement essentially has to be proved like any other fact and in accordance with law.
This is also relying upon Ashok Chand and Magas.
Uh, in the case of Nazir Khan and others versus State of Delhi, reported in Swanso, the Honorable Supreme Court has discussed while discussing the evidence regarding confession has discussed about the word voluntary, which means a statement made of free will and accord of the accused, without coercion, whether from fear of any threat of harm, promise, or inducement or hope of reward. The Honorable Court further held that if the facts and circumstances surrounding the making of the confession appear to cast a doubt on the voluntariness of the confession, the court may refuse to act upon the confession, even if it is admissible in evidence. The question whether a confession is voluntary or not is always a question of fact. A free and voluntary confession is deserving of highest credit because it is presumed to flow from the highest sense of guilt. In the case in hand, as discussed above, apart from the fact that none of the witnesses to the extrajudicial confession have stated about their presence in the meeting, the there appears to be discrepancies in their statement, in as much as two of the witnesses have stated that while confessing the guilt, the appellant also stated the reason for commission of murder, whereas the other two witnesses are completely silent in that regard. And one witness, like PW3, has stated that the appellant did not come to the meeting place at all. In view of such evidence, it creates doubt about the extrajudicial confession stated to have been made in the village meeting. Moreover, the surrounding circumstances under which the confession is stated to have been made, it is very difficult to accept that accused on her own volition, repenting that he has committed the crime, came and disclosed before the members present that he has committed the crime. Stop. Therefore, we are not inclined to accept the evidence of PWs 1, 2, 6, and 7 relating to extrajudicial confession made by the appellant in the village meeting. In a case, next part, in a case of circumstantial evidence, motive assumes great significance. But in the case in hand, the prosecution has utterly failed to prove any motive on the part of the appellant. The evidence of PW1 that the appellant and the deceased were living together peacefully, and the evidence of PW3 that for 8 to 9 years they were staying together as husband and wife peacefully, and the evidence of PW6 that they were having children and there was no history of quarreling with each other indicates that there was lack of motive on the part of the appellant to commit the crime. Next part. So far as the recovery of Tangia or the instance of the appellant is concerned, not a single independent witness has stated about such recovery or the instance of the appellant. The investigating officer who has recorded the disclosure statement of the appellant and prepared the seizure list of the Tangia has not been examined by the prosecution, and only the disclosure statement has been proved by the IO bracketary PW8, who subsequently took over investigation from SIR server. In absence of any evidence that on the basis of the disclosure statement, the appellant led the police party and others to the place of concealment of the weapon of offense and The place was not accessible to all, and in absence of any evidence that that particular weapon was used for commission of crime, the recovery becomes immaterial. In the chemical examination report by Exhibit 17, it appears that no blood was found on the tangia.
May I interrupt you? There is no
Therefore,
blood stain.
we are of the view that on the basis of the available material on record, it cannot be said that these circumstances have been firmly established by the prosecution and they form a complete chain, and from the circumstances it can be said that it was the appellant and appellant alone who was the author of the crime. Law is well settled that suspicion, howsoever strong, cannot take the place of proof. Surmises and supposition has no place in criminal trial, and there is ocean of difference between may be true and must be true. And the prosecution has to travel the entire path by adducing cogent evidence. In view of the foregoing discussions, we are of the view that the conviction of the appellant under Section 302 of the Indian Penal Code is not sustainable in the eye of law. Accordingly, the same is hereby set aside. The jail criminal appeal is allowed. Is he been released on bail or he is in custody?
He's in custody.
The appellant is in custody. He shall be released forthwith. अच्छा এইটাও লিখে দেবে the Land and Council for the state has produced documents from the jail authority to show that the appellant is still in custody. He shall be released forthwith if his detention is not required in any other case. So put a note of appreciation. Yes.
I beg your pardon, my lord. My lord, item number 5 is my item, my lord. And I want to verify some document from the trial court record. I may be permitted, my lord.
Give your pen drive.
Yes, my lord.
Yes, sir.
Please be item number 24.
We take up
Tomorrow.
not today.
Oh, bless.